Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give your attendance, and you shall be heard. Constituted Commonwealth of Massachusetts, Court is open, please be seated.
And good morning, everyone. Welcome to the March 7th, 2024 sitting of the Massachusetts Appeals Court. Sitting to my right is Justice Rachel Hershfang. To my left, Justice Christopher Hodgens, and I'm Eric Neyman. We will be your panel this morning. Appeals Court rules dictate that each side has 15 minutes to present argument. There is no rebuttal. I assure you that the panel is well prepared, so we urge you to cut to the heart of your argument. Final housekeeping business. We go by the clock, so when the red light goes off, please stop your argument. If we see fit to give you more time, we will do so. Check with my colleagues. Anything further? Calling the first case, docket 23P696, Commonwealth v. FLOHR. This is a Commonwealth appeal. We'll hear first from Attorney Jansen.
Good morning. May it please the Court.
Morning.
Catherine Jansen for the Commonwealth. The Commonwealth would ask that this Court reverse the allowance of the motion to suppress. The Commonwealth's position is that the motion judge erred in finding that while this was a close case, that there was no additional plus factor presented. The Commonwealth suggests the confluence of factors, including the plus factor of the out-of-state plate being significant to both narcotics detectives and their evidence in the record.
Where does this language plus factor come from? Is that actually from our case law, or are you just adopting what the appellant uses?
Well, I am adopting the language used by the motion judge, but I believe, I can't point to a specific case if there is the plus factor language is used, but I do think the cases talk about whether or not additional facts have additional weight. For example,
the reason I ask is I've seen a number of cases recently, we've seen, where this term plus factor is used, either in a reasonable suspicion or a probable cause analysis. At least that argument is being made. But I don't know of any published cases where we have used the term plus factor.
well, and perhaps and I can't tell from the top of my head, but there might not be, because when you're looking at probable cause or reasonable suspicion, it's based on the totality of circumstances, and different factors are afforded different weight, and some factors, depending on the record and how they're developed, may be afforded more weight than others. So, I adopted the plus factor from the motion judge here, but it would make sense that it really wouldn't be part of the case law, because we're supposed to be looking at everything in the totality. And here there was a significant factor, I think, that could be afforded weight, that this was beyond just a planned meeting and a quick handshake. And here the record is fully developed about the out-of-state plate, specifically Maine in this case, and the significance of that to the officers. Indeed, Officer Vargas on page 38 of the transcript testified that he knows that people from Maine or out-of-state come to Lawrence because there is a larger quantity of drugs that can be bought for a cheaper price, and he learned that from speaking with people who he's arrested for purchasing narcotics. So this is different from Cordero or the concern articulated by the SJC that just a random opinion by an officer who's not from that quote-unquote source city should be afforded maybe less weight or be viewed with concern, because here there is a significant basis in the record. So in that, and I want to be clear, the officers didn't just stop this car because the car was from Maine.
Yeah, that would be a problem, wouldn't it?
That would be a problem, but that is totally fair and reasonable in the officers' training and experience, and these officers were part of the narcotics unit in Lawrence with experience in doing drug investigations and drug arrests, that this brought their attention to this vehicle, where they continued to watch this vehicle and see what it was going to do, and if anything else would add to their suspicions, and that's in fact what occurred here. The fact that they saw this car driving around in a small geographic area that was close to 495, which is an access road to a highway that goes to Maine, and that they parked in a side street for 35 minutes. The two passengers did not get out, which was a little weird. I think Detective Berner testified to it, but again, alone, not enough. Then they drove away, went to a Dunkin' Donuts.
Right, we know the facts. We have the car stopping 3 separate times. We have the passenger of the vehicle getting out, talking to someone, ostensibly going back to the to the car, having an exchange, and then going back and making an exchange in front of the car. We know the facts. So let me get to the questions. To me, one of the difficult things about this case is Judge Gaffney, for whom I have great respect, but he did not make a credibility determination. So he didn't say anywhere, whatever facts he wrote in his findings, we obviously accept, absent clear error. And I don't think there's any allegation, but Attorney Schneiderman can tell me otherwise, I don't see any allegation that the facts are clearly erroneous. With that said, nowhere does he state, I credit the entirety of the officer's testimony, or even I credit the officer's testimony. So are we bound solely by the facts that he put in his brief set of findings?
I would suggest,
because under Jones-Pennell, I think he has to make that determination. First, I find them credible, and then you can draw inferences from the remaining facts that are reasonable.
I would suggest that it's implicit that he found them credible. Maybe I'm wrong under Jones-Pennell in my reading of Jones-Pennell and the subsequent case law, but where he didn't discredit, in most cases I often see that I discredit them on this fact, or I don't credit them in full, or I only credit the facts as found. And I think it's implicit here in the facts that are supplemented are consistent with his findings. They just add context to those findings. But if the court were to disagree with me that you can't supplement beyond what the limited facts that he did find, based on Jones-Pennell, I still think there is sufficient reasonable suspicion here based on the facts that we articulated that, like I said, he just gave context. The additional facts supplemented gave context to his findings, and I think those findings would still be sufficient based on all the things that we just talked about.
This isn't really a case where it's turning on the facts. It's real because the judge really made a legal determination that the facts that were before him were just not sufficient for a threshold inquiry, right? I mean, it's really a legal question that we're deciding today, right?
Correct, and I would suggest that that was wrong based on the case law. I think the best case is Santa Maria, which is cited in my brief, where their officers were in an area known for drug dealing, which I would suggest here there was evidence that Judge Gaffney found, even not supplemented, that this was an area known for drug dealing, that they had made arrests there, and that they watched an officer in their training experience watch facts unfold that were consistent with a drug deal and a quick nature of a handshake. In Santa Maria, I think the facts were a little bit different, a little bit stronger, but there the court found probable cause. Here we're looking at reasonable suspicion. So I still think that's a good case for us. And I think what's different from Kearse and Barreto, which I think are probably the cases the Commonwealth would have to overcome most recently, there was nothing additional to color the nature of the transaction. Here, even the facts found by Judge Gaffney were that the out-of-state plate was significant to them. In Barreto, in a high drug area, and then watching this quick nature of exchange. In Barreto and Kearse, in Barreto, there was not a high drug area, and they just watched somebody come out of a house and go back into a house, and nothing to color the nature of the transaction. And similarly, in Kearse, it was just a high crime area generally and a quick handshake. And I believe that the parties did talk a little, but I can't totally remember off the top of my head. So I would suggest if you're looking at just the law, Judge Gaffney erred when applying the law as found by this court in the SJC.
I want to be sure I understand the distinction you're making, because I didn't see you going here in your brief, and maybe you're not going there now, but is the position you're taking today that if all of the facts had been the same as those found by Judge Gaffney, but the car had Massachusetts plates, this would fall short of reasonable suspicion?
No, because saying all the facts found by Judge Gaffney, if it had been Massachusetts plates, but Judge Gaffney had also found that the registration was an hour and a half away, or that it was a significant distance away, I still think that would take it. It's not just out of state; it's the fact that it's coming from far away into this city. So I think that would be fine. But here on these facts, the out-of-state plate is significant.
Now, you did a very good job in the brief of lining up all the facts. But one thing that occurred to me as I was reading it is I was thinking that, 5 years ago, this is clearly a clandestine rendezvous that's taking place. But things have changed in the past 5 years that with people buying and selling things online, and they meet in different locations, and they're legitimate sales. So what do you say to that possibility that, maybe there was just an exchange here, but it was an innocuous business transaction?
Well, I would say to Commonwealth VO Day 40 Mass 296, that's in my brief, and the police don't, just because there's innocent explanations for something, doesn't mean that they have to, it undermines their reasonable suspicion based on their training and experience, which what they're seeing, the silent movie of what they're seeing is based on that, and here there was testimony to that effect, if the court were to supplement that this is how transactions occur, and look, this is what happened. And I would also point out 5-6 years ago, I still think people were doing Craigslist exchanges also. It's
Maybe that we're old, and what it really means is 15 or 20 years ago.
Right. Understood, Your Honor. I'm happy to answer any other questions the court may have.
Seeing no further questions, thank you.
Thank you.
Attorney Schneiderman.
Good morning, Your Honors.
So while you're getting ready, I'll give you our first question here.
Sure.
Can you help us sort through the correct record we're going off of here? The reason I ask this is because both you and Attorney Jansen cite to the hearing transcript in your statement of facts. But here, as you're aware, Judge Gaffney made factual findings but did not use the magic words. He did not say, I credit everything the police officers testified to. So do we go strictly off of his findings and we're confined to that world? Or can we also look to the motion hearing transcript and take pieces of that inferentially the judge accepted?
Your Honor, I'm very glad you asked me that, because that's actually where I wanted to start, which was Garner reaffirms Jones-Pinnell and says the facts have to be undisputed and they can't detract from the motion judge's ultimate findings or spur a reversal. And I think to Your Honor's question that you asked my sister a moment ago about findings about the nature of Maine, there's nothing in Judge Gaffney's findings that goes beyond that. At my addendum 73, he discusses where the car was registered, but he does not go further to say, I credit Officer Vargas or Detective Bruner who said that this is coming from Maine. So I think the Commonwealth's contention to rest suspicion on the Maine plates would indeed be in collision with Garner and with Jones-Pinnell, and also, as I laid out in the brief, Commonwealth versus Chown, which says you can run an out-of-state plate. If it comes back normal, the person has the perfect right to drive on the highways. And moreover, Your Honors, to further suggest that presence from Maine makes this a valid stop overburdens the record. If, actually, a la what Justice Hershfang asked my sister, if the officers had been sitting at the on-ramp to 495 in Lawrence, there is an on-ramp at South Broadway. If the officers had been sitting at the on-ramp, then that would be a different story. If they had followed the car, then the inference might be reasonable. The inference is ultimately unreasonable here, where this car passes them by. There's no tips. None of the occupants of the car are known to the Lawrence police. I think it's ultimately unreasonable, and it would indeed collide with Garner and Jones-Pinnell.
So, long story short, our universe should be confined to the judge's explicit findings of fact, and we're not to supplement that from the motion hearing in this case, or may we?
Your Honor, you could supplement it if it were undisputed. It was not undisputed. There was cross-examination at transcript 27 and 47 about this issue. So the judge had to somehow sort that out, and the judge didn't do that. So the Commonwealth asking for new inferences or new findings from that collides with Garner and Jones-Pinnell. Before I get to the rest of my argument, Your Honor had asked a moment ago about where this plus factor comes from. I glanced as quickly as I could, sitting at counsel table. That's something from the constructive possession case law, most recently Commonwealth versus Nova 101 Mass App 1. I'm not sure why the motion judge opted for that, but that's just my look at it, just sitting at counsel table here right now.
I've seen it in Rule 23 cases, but that's not precedent, so.
Certainly not, Your Honor.
Okay.
Can I press you just for a sec, since you were kind enough, perhaps you won't do this again, to give me transcript page sites?
I'd be happy to.
You say that that was contested, and if I remember correctly what that is, it was the significance of these guys, or of the plates, I don't think we know about the guys, being from Maine. When I look at page 47 of the transcript, that cross-examination seems to establish the name of the driver and the passenger, and that they were not on the radar of the police officers. And then 26, I'm stalling because I'm going about this very inefficiently, establishes that there was nothing that led the officers to believe the vehicle was stolen or that the driver had an expired license or revoked license, anything like that. I don't see anything on either of those pages that challenges the portion of the testimony where the officer says, here's why far away is significant to me. Am I missing something?
I apologize, Your Honor. I had the pages wrong. I was remembering 27 and 47 as to the occupants of the car. Transcript 32, I've just word searched Maine just right now. Transcript 32 is Detective Bruner's testimony about whether or not the person's lost, and transcript 46 talks about, was this run because he's from Maine? And there is another line, the word search, though, is not coming up. But during Officer Vargas's cross, which is from transcript 45 to 55, I'm sorry I can't pin you a better page for that, there is a question in the same vein as Detective Bruner, which is, why is someone here from Maine? Could they be lost? So I think in that light, transcript 32 and during Officer Vargas's cross, that goes to that. I apologize if that was not clear.
No, no worries. But so your position is that a statement by the officer that there is an alternate, possible, legitimate reason that someone from Maine could be pulled up on a side street in Lawrence means that we cannot take the portion of the transcript where the officer testifies as to the relevance from his training and experience, or not even relevance, but why it would raise his suspicions. I lost track of my sentence, but do you know what I'm asking?
I know exactly what you're saying, Your Honor. It would be crediting contested testimony to lead to a reversal, and that would collide with Garner and Jones-Pennell. And as Justice Hodgens suggested to my sister a moment ago, there may very well be innocent explanations. Indeed, I don't really see how Barretto is distinguishable on these facts, particularly in light of how the evidence here that this was a high crime area was very paltry. The officers said at transcript 10 and 11, Detective Bruner at transcript 10 and 11, I appreciate Your Honor's point, let's be precise about the transcript. At transcript 10 and 11, Detective Bruner says, I've made 20 arrests in 8 years in this neighborhood. So to suggest that this is a high crime area, especially in light of Evelyn, or a high drug area, overburdens the record in that light. So to Your Honor's question, it should not be credited, and crediting it would cause a host of problems in collision with Cordero, Chown, Weston W. dealing with the right to travel. It should definitely not be credited, either procedurally or substantively.
And to be clear, you are not claiming that any of the judge's findings are clearly erroneous, correct?
Certainly not, Your Honor. I'm not claiming that any of the facts are clearly erroneous. Again, I'm glad Your Honor asked me that, because as I was listening, I was like, answer that. Your Honors, the question of an exchange, I think the Commonwealth, again, has overburdened the facts suggesting that there was an exchange. The officers...
Two exchanges.
Two exchanges, yes, Your Honor. I think the officers did not see an object. Yes, the absence of an object is not dispositive of that, but there was no money, there was no drugs that were seen. It's not like, I believe it was Santa Maria, it may have been Stewart, where someone was actually counting money. And as the motion judge explicitly found, this is in broad daylight in a residential neighborhood in Lawrence. Nothing here was done.
Why does that matter? You argue that because this is in broad daylight, because it's not done, down a dark alley, that seems to inure to your client's benefit. I mean, does a defendant in a drug case have to have a handlebar mustache and wear a cape and look suspicious? I mean, why is that important here?
Your Honor, defendant need not be a mustachioed villain, but the suggestion that it's occurring in truly secrecy, which the SJC clarified in Torres-Pagan, the demonstration or facts that are probative of real secrecy to hide it, that would be more probative of a drug transaction. And here, again, I think we run into a Garner and a Jones-Pinnell problem, which is to infer additional secrecy that way would be to collide with the motion judge's findings.
All right, but let's put all that aside for a second and go back to the basics. So in Terry v. Ohio, there were very few facts at all. You had Detective McFadden just watching two people walking back and forth down the street, occasionally looking in a store window, conferring, meeting up with a third person, then walking away. And that was enough for a threshold inquiry. And that was at 2 o'clock in the afternoon.
Your Honor, I think that Terry has been, or at least the SJC has refined the assessment of a Terry stop in more recent case law, like Evelyn, like Barretto, so on.
Under Article 14.
I beg your pardon?
Under Article 14.
Under Article 14. So I think even though Terry, I don't disagree with Your Honor's characterization of Terry, but here there is not enough. I think the question of plus factors maybe misses the mark here. There's not enough to transform this into a drug transaction. Unless Your Honors have further questions, I ask that you affirm, and I thank you for your time.
Just one.
I'm sorry, Your Honor.
That's all right. So what were the officers to do then? They've seen what they think is a drug transaction. They're following a vehicle that they suspect will have evidence of that illegal act. You say it wasn't enough to stop. I'm going to ask you to do a very difficult thing and imagine yourself into the body of one of those police officers. What were you to do then in order to do your job?
I would, if I were Detective Bruner, if I were Officer Vargas, I might make out an FIO report, or I might urge that the truck be continued to be followed. I would not engage, though, in a stop, particularly whereas here, actually, if the match that lights this fuse is out-of-state plates, that match would ensnare me because I have Connecticut plates.
Shame on you.
So I think in that light, because the match was Maine plates, that's impermissible. And to rest suspicion on that match lighting that fuse set off a bad bomb. Unless Your Honors have further questions,
No. Thank you very much.
Thank you.
Well argued. The case is submitted. Our next case, docket 22P296, Commonwealth v. Leacock. And good morning, Attorney Benyon.
Good morning.
Nice to see you.
To the presiding justice, and may it please the court, let's go ahead and start talking about the difference between force and constructive force, or force to rape, or statutory rape. It's the legislature through that process, through the lawmaking process, that sets the statutes. In this case, I would argue there are two very easily understood and interpreted statutes. In fact, we even in Massachusetts have a statute that tells us how to interpret the words of a statute. I cited it for you. You just use the reasonable everyday usage of the term of force. And in that case, what we're looking at is if the government is going to bring an indictment for rape by force, there has to be actual force or threat of force to compel the victim to submit to the act. In this case, and just so you know, I'm not talking about all of the indictments. We're just looking at counts 29 to 56 and 57 to 68. These are those that, through the victim's own admission, there was no force, there was no threat of force. This is statutory rape.
I think that might be the case as to a number of indictments, but there was language with respect to the conduct in Foxborough, and this is a transcript, volume 4, pages 21 to 25, where the victim testified that the defendant put his hand on her head and put it towards his penis. That was the testimony.
That was the testimony.
That can be construed as force, it seems to me.
That can be construed as force, and with that particular one, I would say that goes into my second argument. If you're going to ask the jury to look at force or not force based on the testimony, there really needs to be a unanimity instruction because...
Right, but before we get there...
all right. So
it seems that undercuts your argument at least as to some of the indictments.
It may, however, when you, and I know the portion that you're referring to, you're reading an awful lot into that exchange because that occurs almost at the very beginning. And as we go through the rest of the years up to around 16, she again, I think 2 or 3 points in the testimony talks about how the fact that this was normal, there was no force, there was no, it was just normal for her. And so again, if the government is going to charge rape by force, number one, it needs to prove actual force or threat of force. Number two, if we're going to really take a person's liberty away, there needs to be a unanimity instruction in this case in particular.
So before we get to unanimity, let me just follow up on this. And if I'm misstating your argument, I know you'll correct me. I made that mistake with you once before, and I won't make it again. But my understanding of your argument is that you are saying that the statute requires actual physical force.
Yes, it
and
does.
Constructive force is insufficient under the plain language of the statute.
Yes. Now let's talk about constructive
Now,
force.
just let me finish the question, though. I will let you get there. If we agree with you, would we have to overrule our holdings in the cases you cite, Armstrong, Haynes, and Moniz?
And Newcomb.
And Newcomb.
So this is kind of one of those interesting legal issues. And the point is, under Article 30, when does a judge's interpretive power begin and the legislature's legislative power end? I cited a wonderful quote by Bishop Hodley. It's in the footnote. I'm sure you all read it, and we're wonderful. It's great. He who hath the absolute power to interpret any written or spoken law, it is he who is truly the lawgiver, and not him who first wrote or spoke the law. Words of a statute matter, and the case law is clear that you as judges are not allowed to change or alter statutes. So let's talk about constructive force. Constructive force is a case law-driven doctrine designed to circumvent the clear language of force. Now, I'm not saying that constructive force is a mythical term that has no application in the law. It actually does. And I would like to read you from Black's Law Dictionary the definition for constructive force. Quote, constructive force, threats or intimidation to gain control or prevent resistance. That's threat. That's why the legislature used the word threat. That's why it has to be actual force or threat. Threat is constructive force. What the courts have done is say that the status of a person can be used to create constructive force, which is
Extra vulnerable victims, right?
is a ridiculous interpretation because the legislature knows how to write in language that takes into account the status of a person. The best example is age. We have the age in the statutes. If the age of a person is longer than 5 or 10 years, you can move the penalty up. So the legislature knows very well how to do this. They never said constructive force, and they could. The legislature knows full well how to say.
Legislature ever used the term constructive force in any Massachusetts statute?
No, not that I'm aware of.
Right,
But,
or in possession, we have constructive possession.
as I just read.
Have they ever used the term constructive possession in the statute? I don't
no,
think
but they
so.
use the term threat. And threat is the definition for constructive force. It's not the status of the perpetrator.
And your
again,
authority for the notion that threat equals constructive force is Black's Law Dictionary, the plain language, right? You're not citing any.
Plain language.
But you're
And
not
how
citing
easy-
any case law that says that.
No,
Okay.
because you don't need to. That's playing a semantic game. The legislature knows what, again, our job as lawyers and members of the bar is to interpret the statutes reasonably, and we do that by applying, not in every case, but in most cases, just the reasonable everyday usage of the term. And the term force or actual force or threat, these are understood by everybody. You actually have to have kind of the court coming up with and explaining this idea of constructive force plus, which is, you know, the status of the perpetrator. But again, the legislature knows how to do this. They know how to write in a statute.
So go back to my question.
Okay,
Do we have to overrule to agree, if we agree with you? I mean, I'm a big fan of Article 30, by the way. If we agree with you, do we have to overrule the cases I referenced earlier? Seems to me we would.
yes, you do. If you believe that your oath is to the law and not necessarily to the SJC, I understand where this doctrine has come from. This is actually a very interesting debate. It's in the law articles and law review. You know, does an intermediate appellate court have to follow the precedents of a clearly wrong higher court?
You know, but the world doesn't spin on the axis of the legislature and the courts. You're forgetting about one important factor here, and that's the jury. And the jury was instructed on just what you're saying, to take into you can take into account many factors when deciding whether or not force is used. And the
Yes,
jury came to the conclusion that, yeah,
But the
force
way
was used.
But the way the judge defined constructive force certainly allows the jury to come back with a guilty verdict, but the instruction is erroneous if you're looking at the statute. If you're getting the factors, the elements of the crime from the statute written by the legislature, not the SJC, then the instruction was erroneous because the court said you can take into factors of the perpetrator's status to find force, constructive force. But that's not really what constructive force is. Constructive force is a threat, but that's already written into the statute.
Yeah, but still, jurors have to have some understanding of what force is. I mean, they don't go into their deliberations untutored. They have to get some kind of instruction from the judge, don't they?
That's what I'm saying. If you leave a jurist alone, they're going to have the reasonable idea of what force or threat of force is to compel someone to submit. But then when you have a judge, a person on a high rostrum, in a black robe, who's given authority and tells them that, yes, we all understand what force and threat of force is, but I want you to also understand that you can also take into account the status of the perpetrator, that's where the problem arises, because the legislature never allowed a person to be put into prison for their status unless they wrote it into law. So for example, in a statutory rape case, you know, the age of the perpetrator.
What do you mean by status? You mean the fact that it's an 11-year-old child that
Or usually the language is
begin
somebody,
with?
an authority figure. That's what I mean by status, or what's usually here. But status can also refer to like the age of the person or how they influence the victim. That's what I mean.
Though, I mean, I can't, and if you have a site, I'd be delighted, because I can't find that portion of the jury instruction off the top of my head. But focusing on the case law, I think you need to give it its due if you're asking us to throw it out the window, and I don't think it says something quite as straightforward as what you're saying. My read of Newcomb and Armstrong and those cases is not that there is some kind of sort of easily applicable thing like age as you know, in the statute, but not this statute or status, but that actually you look at the constellation of the facts surrounding the relationship between the alleged victim and the defendant, and that those interactions over the course of years, including things like that it was her father, can be taken into consideration.
I have a citation for you. It's the statute. It says force or threat of force, and the court can't change the reasonable meaning of those terms, which is what the court has done.
But what did the judge say to this jury about constructive force?
He defined it as did I not put that in the, I might not have. I was
Sure you did, and I probably
I was running up to some page limits on this brief in particular. But I can tell you assuredly that the judge gave the same constructive force statute that is in the jury.
At volume 7, page 32.
There you go, thank you.
Thank you, Justice
With constructive
Brennan.
force. When thinking about constructive force, you can think about all of these factors, including the victim's age, sophistication at the time, fact of whether the defendant was an authority figure in her life, et cetera, all the things that came from the case
That's, I
law.
think,
But of course, the
close.
legislature never said that. They said they want the judges to distinguish force and threat of force that compels, or it's statutory rape.
Sorry, it's
And I'll
volume
just
7,
point out-
page 65.
I'll just point out that the statutes for both rape by force and statutory rape do carry up to life sentences, but they usually, it's the force that is used to kind of in the sentencing guidelines as a factor that's a little bit more harsh. And that's the problem here. This case is a good one for this issue because the testimony was so clear that this began at such a young age that she didn't think it was wrong. There was no force used to compel from the beginning up until the middle of her 16th year. All we're asking you to do is to apply the statute as written, taking the terms in a reasonable way that the jury would have understood them. The constructive force, the way the judges give that instruction, it makes no sense. That's my cup. I can constructively possess that. We all understand that. That is, I get it. But I remember the first time I read the constructive force issue, and my brain short-circuited. And I still can't understand it. Again, the court needs to, if it's going to take away the liberty interest of a citizen like my client, he has the right to say the government has certain elements that they need to hit, and if they don't hit them, he needs to be released, or not, or at least finding of innocence on that charge.
I promised we'd let you get to the specific unanimity issue, so please go ahead.
So again, specific unanimity also just jumps off the page when you look at these ideas. Again, specific unanimity is important because, yes, she does talk about that almost first instance where he touches her head, and then later towards when she's 16. But even 16, the idea is that she relented, but it wasn't through force or intimidation. It was just to make life easier for herself. Again, that puts it in statutory. And when you have this is a fairly large indictment. When you have all these, you really need to show the jury that they need to be unanimous on each count. That's what's important here. With respect to the last argument, this is what my client feels especially strong about. Please make sure that you, and I again ran into some page limitations here, but I would ask that you please read the amended motion for new trial, paying attention to the police report that's addended to that, where the police enter the house. That's the main issue that he really wants to put before the court.
One question about the amended motion for new trial, and I understand it was filed by counsel other than yourself. With that said, one of the claims was ineffective assistance, and 3 different grounds were raised. It did not raise what you raise in your brief here, which is ineffective assistance predicated on the failure to give or to ask for a specific unanimity instruction.
Yes.
What does that do to our standard of review? I assume it just means that we're at the substantial risk standard here.
It does mean it's at a substantial risk on that idea, but you also need to show, or it needs to be plain on the record's face. So normally you need a motion for new trial to raise the issue. What I'm saying is ineffective assistance of counsel on a claim with this many counts, with this, and the way that the Commonwealth presented it was to run through each year of her life, if you read the transcripts. So it really dilutes it. So I'm arguing that it's plain on its face that counsel should have raised the specific unanimity issue. And then you say, then you move to the substantial risk of miscarriage of justice. Thank you
Let me see
very
if there are any
much.
further questions. No, thank you, Attorney Benyon. And we will hear from Attorney McGee for the Commonwealth.
Good morning, Your Honors. May it please the Court, Michael McGee from the Norfolk District Attorney's Office. The defendant began sexually assaulting and raping his daughter when she was 11 years old. He did it whenever he wanted, throughout the home, avoiding her mother. He exploited his relationship, isolated her from normal relationships, and preyed on a young, vulnerable, sexually inexperienced girl who was new to the country. Evidence was overwhelming to sustain the forcible rape convictions on both the physical and constructive theories of proof. Evidence was also more than sufficient that the defendant took his ability to consent at age 16 when he began raping her at 11.
So there are dreadful facts in this case. We're familiar with the facts. Let's cut to the law.
Mm-hmm.
Under what authority should the judge instruct under 22A on constructive force as opposed to actual force?
Commonwealth versus Armstrong, which both parties cite, is an excellent case on point here. In that case, evidence was sufficient for rape of a child with force, a non-physical constructive force. And in that case, similar to this one, the defendant was an authority figure. He was a stepfather in that case, a step-uncle, so she was a step-niece. There was an age disparity. She trusted him, and in the facts of that case, she suppressed the sexual conduct and pretended she was asleep, and those were similar facts to what we had here, where...
Does Armstrong actually explain why force may be constructive even though the statute doesn't necessarily say so?
What Armstrong talks about from a very factual standpoint is that when you have a younger person that lacks maturity and has somebody that is domineering over them and that has that power and control over a young person, that the force is inherent in what is going on because they lack that they don't know any better, that there's this authority figure in their life that is taking their ability away to consent, that they don't even know what is going on. And in some respects, they think it's the appropriate thing to do. We're talking about 11 to a 15-year-old girl here, that on a daily basis, her father is coming into her bedroom and demanding sex. In some cases, forcing his hand on her to have oral sex. But he's doing it throughout the house where her mother's cooking in another room. He's using his fingers, he's caressing her, kissing her, as she described it, like somebody that would be married.
So is your argument that any time we have a familial relationship and there's a child rape or child sexual assault, by definition, there is going to be constructive force?
What I would suggest to the court, and what was, I believe, an appropriate instruction, as Your Honor read, is that under a totality of the circumstances type case, or inferences that could be drawn from the facts and testimony of the case, it would be appropriate for a juror to conclude that the victim was forced to have sex because she did not have the ability to say no.
I get that under the facts of this case. My question's broader. Are you suggesting that any time we have a case like this, involving, let's say, father-daughter rape of a child, that by definition, there is always going to be constructive force?
I think there are...
If so, that might be an overbroad reading of 22A, and there's no distinction then between 22A and 23, as Attorney Benyon states. So I'm trying to resolve that.
What I would suggest is that there are certain cases where the gravity of the facts and the circumstances of the relationship and the authority that a person has over that young individual would suggest would be appropriate for that force, that constructive force, like we had here in this case. These are, as Your Honor, these are horrific facts that were perpetrated over the years of 11 to 15 and continued after the victim was 16. And as I was stating, that he in fact took his daughter's ability to consent at age 16 when he began raping her at 11. And all those cases, Wallace, Moniz, and Newcomb, that line of cases talk about that when an individual has been sexually assaulted and raped at a young age and the pattern continues, that they lack the ability to consent to the sexual conduct.
So if you trace back this constructive force theory, it goes back at least to, and I haven't gotten any deeper, Commonwealth versus Caracciola. My Italian is not very good. 409 Mass 648, in which the court, and now I'm just reading from the head note, which is not part of the case, so if I get this wrong, blame Westlaw, held that evidence the defendant told the victim that he was a police officer and would lock her up if she did not obey was evidence of use of force. That is pretty plainly a threat. I trust that you would maintain that the development of the case law from that pretty plain threat to the situation in this case, in which if there's any threat at all, it is at most implied or understood, but not direct, is sustainable because it's, I think you would argue, the same type of imposing his will on the victim. Is that fair?
That's correct. And these cases, and I was looking for a site for it, but what is developed and is consistent is that that this force can be proved by actual force, threat of force, and constructive force. And I know it's cited in my brief, but in any of those forms, it can be proven. Right.
I guess what I'm trying to get at is Attorney Benyon is arguing, not without force, that, sorry, that was a bad pun that I did not intend, that this statute doesn't say anything about constructive force, that if you read the plain words of the statute, it says force. And everybody who speaks English knows what force means, and that this constructive force is sort of a judicial engraftment onto the statute that ought to be excised.
He raises that at argument and partially in his brief. What was properly before this court is whether the facts of this case were sufficient to survive a required finding. The idea that the statute is vague or that the legislature, that there's something wrong with the statute isn't properly before this court. These facts here were overwhelming of the kind of constructive force, of actual force on this young individual from the age of 11 to 15. And I know your honors have read the facts, but the isolation from her mother, I think, sorry to interrupt you, but my understanding of your brother's argument about the constructive force is that it actually goes to the later allegations. So after she's 16, when she's reached the age of consent. On sufficiency grounds, and I pointed those three cases out, Moniz, Wallace, well, I started with Wallace, went right on to Newcomb and Moniz, talk, and all three of those cases from 2010 to 2015 talk about individuals that have been sexually assaulted at a younger age, and it continues on, that they lack the ability to consent because they believe it's normal, that this is a normal activity in their household, that somehow, or that they set it aside in their brain and they say, well, this is an authority figure and I just want him to go away and I'm simply just going to let him do what he's going to do. That is force. You call it constructive force. It is unwanted. It is non-consensual sex. And that's what happened here. You have somebody that's resisting, saying she now is starting to understand that she doesn't like this, that now she's saying she's trying to find excuses not to have sex with him. That's resisting. She did not want to have sex with him. She knew no other way. She's new to this country. She only knows him. He's her, she thought he was her best friend. He's kept her away from her relationships with others, won't let her, picking her up from work, standing outside of her workplace and staring at her and telling her to come home. Doesn't, as she gets older, getting upset about relationships she has with other people and that she's sleeping over her boyfriend's house. These are all, under a totality of the circumstances, shows of authority and control over her life and forcing her to have sex. None of this was consensual. Given that totality of the circumstances, the jury was it was appropriate, and the judge was well within his authority to deny the motion for required.
Isn't this really, I mean, it all boils down to being a jury question, doesn't it? I mean, not only does the judge provide an instruction on what constructive force means, but the judge also, which is typical, reads a portion of the statute to the jurors. So, for example, whoever has sexual intercourse or unnatural sexual intercourse with a child under 16 and compels her by force and against her will or compels said child to submit by threat of bodily injury shall be punished. So, jurors have all of that in front of them. They have the evidence. They have the instruction on constructive force, and they have the actual language from the statute. So aren't we really dealing with a jury question?
And counsel raises no issues with the juror instructions on those points. And what I would suggest to you is that this was, that the jury was very thoughtful here. They found the defendant not guilty of several of these counts, including 3 of the counts the defense counsel argues should be overruled. 53 to 56, he was found not guilty. So the jurors listened to the evidence. Those were specifically the 2010, when she was 15, crimes, and they found him not guilty of those offenses. So they did listen to the evidence. They did listen to I think we can infer that the instructions were appropriate, and that and we are too, and it's evident from the facts here. Additionally, there was, and this goes to the specific unanimity argument, there was a very thoughtful discussion and instruction to the jury about how all of the verdict slips had the specific sexual act on them and the dates for each of the verdict slips. So all 74 of these verdict slips, the court and the Commonwealth went through and put the dates and the specific act on the verdict slips. And then the judge explained that to them, and that they had to decide each act on each verdict on its face.
So let me ask you a question about the unanimity issue. Insofar as that issue was not raised in a motion for new trial, do we have a complete record here? And by that I mean this. Could there have been a strategic reason for defense counsel at trial not to seek a specific unanimity instruction? I don't know whether or not I can think of one, but I'm going to put it to you.
What I could only glean from the record is that there was at least several pages pre-trial about these verdict slips and whether the parties were content with them. And I can't read a defense attorney's mind about why he was content with it and the way that they were prepared. They were simply, that was the discussion. To your point, and I raised this in my brief, it was waived. It could have been raised. He raised ineffective assistance counsel claims at the motion for new trial.
Oh, I understand.
Did not,
It
so
wasn't
all
raised.
this is not. So it is a substantial risk standard.
Right.
And
So let's go back to my question.
yeah.
Can you conceive of a strategic reason not to seek a specific unanimity instruction under these facts? Our questions aren't always supposed to be easy, so this is...
The only thing I could, I suppose an attorney may think that if there's not a specific unanimity instruction given, that his client may be found not guilty of, I don't know, from a certain period, like, I don't know, maybe, I don't know, maybe found, I have no idea, I can't answer. I don't practice defense work, so I don't know why this would be strategic. But it wasn't raised, so we don't have a full record before the court, and that's why it's waived, and that's why it should be reviewed
The
for
light's gone
substantial
off,
risk
but
of
you can finish your thought. Go ahead. Like to
There are
sum
no
up.
other questions. I would rest on my brief and ask you to affirm the convictions.
Seeing no further questions.
Thank you very much.
Thank you. Well argued by both counsel. The case is submitted. And before we call our third case, I would just like to acknowledge some students from Boston College Law School who are here visiting us today. Calling docket 23P621, Commonwealth v. Brown. We'll hear first from Attorney Osborne.
Thank you, Your Honors. My name is David Osborne, and I represent the appellant Andrew Brown in this case. Mr. Brown was convicted of 2 counts of violating a restraining order. Although one of those convictions has been vacated by the trial judge, and that issue is actually not before this court. The issue is actually whether he should be retried or the count should be dismissed outright. And I'll talk about that in a moment. He brings 3 claims, one involving count 1, one involving count 2, and the third is simply an evidentiary question of, on a retrial, what kind of evidence can the Commonwealth present? The Commonwealth, by my reading of its brief, concedes the merits of claim 3, so I don't believe we need to discuss that unless Your Honors have any questions about it. And I'd like to, getting into the 2 claims that remain, I'd like to talk first about claim 2, if I can go in reverse order, just because it's actually a very straightforward, simple claim. And then we can get into the weeds of double jeopardy on claim 1. But claim 2 is, involves count 1. And in that case, on count 1, Mr. Brown was convicted of violating a restraining order. And
The conduct in count 1 is October 20th, 2021.
Well, that's the problem. So the problem with the way this case was prosecuted, to be frank, it's a bit of a mess. What happened was count 1 originally, as envisioned by the Commonwealth, it was an October 20th, 2021 violation of the restraining order. And then count 2 was going to be stalking in violation of a restraining order that took place over the period of October 20th and October 21st.
And one of the problems is no one thought about what might happen if the jury comes back and convicts on count 2 on a lesser included offense, right?
Well, that's the problem with regard to claim 1, which
Well, let me
involves
just
count
ask it this way.
Yeah.
If the judge had instructed on count 2,
Yeah,
on the lesser included,
correct.
the judge had instructed, and to be clear, in order to convict on count 2, you must convict of conduct that is separate and apart from the conduct involving count 1. Had the judge
Correct.
said something like that, would the problem have been alleviated?
If the judge had given that instruction, had said it has to be based on different conduct, I believe it would with regard to double jeopardy, but not with regard to specific unanimity. But we don't need to get in, because the specific unanimity problem exists with regard to both counts. We just don't have to address it in this appeal because the judge has already vacated it on that ground.
And there's no cross appeal.
Yeah. So this claim on claim 2 involves a specific unanimity problem with count 1. And the problem is that although it was envisioned originally by the Commonwealth as a single violation, and I take it that the Commonwealth in good faith intended it to be that. It seems like the parties and the judge all understood that was the way the charges were structured. The problem is it's not what's in the head of the Commonwealth or the judge or the trial counsel. What matters is what does the jury understand about it. And in this case, the jury has been given no indication that count 1 is limited to this single violation on October 20th. In fact, it's quite the opposite. The prosecutor in this case argued both in opening statement, but even more in closing, more acutely in closing argument, that all this evidence, and there was about 5 or so actual live violations that were argued. There were some that the judge struck during the witness's testimony. So there's about 5 actual allegations of violations. And what the
Let me ask you about that, because, okay, so there are 5. We have a 209A order that prohibits a number of things, but one of them is no contact.
correct.
And in each of these 5, we have instances where the defendant is making some kind of contact with the victim.
That's the allegation, correct.
Right. So we have the one 1011, he's kind of circling around her in his car, revs the engine outside the daycare. 1014, there's the argument outside the court between the mom and the victim, and then the defendant intervenes in that, starts yelling at the victim. 1015, you have the 7 p.m. phone call that comes in from the defendant to the victim's phone. 1018, that's the incident where the defendant's parking his car behind the victim's car, goes over to the door, opens it up, the child's in the back, in view of the victim.
Right.
1020, that's the text that makes all sorts of statements.
That sounds
So
correct, yeah.
those 5 incidents, would you agree that in each of those 5 incidents, there was sufficient evidence for jurors to conclude that the defendant violated the restraining order?
There was, well, that gets into claim 3, which is whether there was sufficient evidence under Lattimore for, and by my count, it's explained in our brief, there's actually only 4 violations of the restraining order, alleged violations of the restraining order that would have met the Lattimore standard. And the Commonwealth concedes that. It says those 4.
Which one does not, out of the ones I mentioned?
I'm sorry, Your Honor. I'd have to check my brief on that. I can tell you which ones we argued met the requirement. It's of Lattimore. It was, well, we say that our alleged violations on the 19th, the 4th, the 6th, and the 15th were not sufficient. There wasn't sufficient evidence.
Okay, so the 15th, that's the only one that I just discussed.
Yeah.
And that was the one where the phone call came in?
That's correct. There was just there was a phone call and...
That wasn't
From a
contact?
blocked phone number. And the Commonwealth concedes that that's not sufficient. So at best, we have 4...
So you're agreeing that that phone call that came into the victim's phone from the defendant's phone shows up on her phone that the call is coming from him, that's not contact?
On the 15th, it was a blocked call, so we don't know. And
There were blocked calls that followed, but the initial call at 7 came from the defendant, correct?
Yes, yes, I believe so. That's correct. But again, whether it's 4 or 5 violations of the restraining order, the point is that there were multiple violations of the restraining order that were introduced into evidence, and the Commonwealth argued these as violations, not just with regard to count 2, but also with regard to count 1. The prosecutor argued you should consider all of this evidence and find Mr. Brown guilty of violating, of stalking in violation of a restraining order and violating a restraining order. That's count 2 with regard to the first, the stalking, count 1 with regard to violating a restraining order. So the judge gave no clarification on that. It wasn't asked to. He did not give any clarification on that. And so the jury went into its deliberations understanding completely, it was completely understandable that the jury would go into its deliberations considering all of this evidence, whether it's 4 or 5 violations. It's not so important. The important thing is they consider that evidence not just with regard to count 2, but also count 1.
But they were instructed, there was an instruction on general instruction on unanimity. The judge instructed them 3 times they had to be unanimous in whatever verdict they reached,
but
right?
it wasn't, yes, but that's not specific unanimity. And here's an important point with regard to the judge's instructions. The judge in this case actually found that it was error not to give the jury a specific unanimity instruction. So that's what's kind of interesting here.
To make sure I understand your argument,
Yeah.
with respect to the conviction for count 2.
Yeah.
Your argument is essentially this. There were basically 4 or 5 violations of the restraining order upon which the defendant could be convicted on count 1, A through E. Without a specific unanimity instruction, we don't know whether the jury convicted on conduct A, B, C, D, or E.
Correct.
Therefore, there can be no retrial on count 2 because without knowing which, the defendant might be convicted for the precise same conduct the second time around.
Yeah, we're almost there, but count 2 is actually a separate question.
But I'm asking about count 2, so that's...
Oh, okay. So count 2 is, and again, we have to get into what the judge ordered.
Let's make this simple.
Okay.
Tell me concisely, but with specificity, what is the basis for arguing that there can be no retrial as to count 2?
The basis for there being no retrial on count 2 is that the judge should not have instructed the jury that there was on a lesser included offense for count 2 when there was already a lesser included offense that was charged. It was charged separately. It was charged as count 1.
But it could be different conduct. If count 1 was A, B, C, D, E.
Not the way it was presented to the jury.
Well, you're talking about the prosecutor's argument right now, which is the jury's instructed that arguments are not evidence. I mean, what's important is what the evidence is in the case, not what was argued.
Right.
And
That's
the jury
correct.
heard
And the-
evidence of multiple interactions or attempted interactions that could have been understood by the jury to constitute violations of a restraining order.
That's correct, for both count 1 and count 2.
And I thought your argument was that the jury has heard this evidence, the jury has been instructed about what it means to violate a restraining order. The jury has been offered 2 different opportunities on count 1 and then as a lesser included on count 2 to convict the defendant for violating a restraining order. But the jury has never been told, oh, here's a really important thing. And now I'm talking about jeopardy, not unanimity.
Okay.
You can't use the same one of those 4 or 5 things to
That's
convict
correct.
under 1 and 2. Okay.
That is correct. There was no separate acts instruction here. That's what gets us to, that's what created the double jeopardy problem. And I'm sorry if it's confusing. It is a bit confusing because count 2 was litigated before I got involved in the case. It was litigated in post-trial, post-verdict motions. So it gets complicated because the judge has actually already made a ruling on count 2, and we can't disregard that. What the judge found was that it's very strange. This is a strange case, so it's actually quite simple. Mr. Brown argued that it was a double jeopardy violation because there's no way to distinguish between what acts Mr. Brown was convicted on for count 1 and count 2. Very straightforward. And the trial counsel raised it in sentencing, so it was actually quite timely, because that's when the double jeopardy problem becomes real. So there's a motion, the judge grants the motion and says, yeah, for all the reasons that the trial counsel argues, which is double jeopardy. So I vacate count 2, and then, but the Commonwealth can retry it if it wants to. And that's where it gets confusing, because trial counsel came in and said, wait, Judge, I like your ruling on vacating, but not so much the retrial. There's a problem. It's still a double jeopardy problem. We don't know what Mr. Brown was convicted on in each of these counts, so it's a double jeopardy.
And we never will know.
And we never will know. Oh, yeah, there's no way to know.
So no matter what would happen in a second trial, it is always conceivable that the jury would be convicting for the second time
That
on the
is
same charge
That is
/
correct.
conduct.
But this is where the case gets a little weird, because the Commonwealth came in and opposed the motion for reconsideration, but then filed its own motion for reconsideration and said, hey, Judge, you know, there's this whole other issue out there. It's specific unanimity. And this is really about specific unanimity. That's the real complaint of the defendant, and that was waived because trial counsel never asked for a specific unanimity instruction. That's true, but it wasn't the defendant's argument. Mr. Brown never raised an issue about specific unanimity. So it was kind of a pointless, it certainly is a problem, but it was a problem that I was intending to raise on direct appeal. But the Commonwealth just brings this to the judge's attention, and the judge, who was actually, Judge McLennan, who was actually quite clever about this, said, hey, you know what, that is another reason for me to vacate count 2. So you know what I'm going to do? I'm going to vacate count 2, and then I'm going to order a retrial. And on that basis, a retrial does not create a double jeopardy problem because it's just a question of re-instructing the jury properly on specific unanimity. So it was actually quite a clever ruling, but the problem is that it doesn't address the double jeopardy problem. And so the weird thing about this case is Judge McLennan's decision is settled in terms of vacating it. So we're done with count 2. The only question is whether Mr. Brown gets retried on count 2, or should the Commonwealth only be able to try him on whether Mr. Brown, a single count of violating a restraining order.
I know you're running out of time.
Yeah, I'm
Just
sorry.
out of curiosity, why did you go to the single justice on this and not just wait for the direct appeal? Was there a danger that this was going to be
Your Honor,
teed
I
up
did
for
not.
trial?
This was trial counsel who did that. I did not go to the
Oh,
single
okay.
justice. Yeah, so that's why it gets complicated. The single justice said, hey, deal with this issue.
Yeah,
Appeals court, you
it's
deal
just
with
a
this issue,
curiosity.
but limited only to the question of whether it's a double jeopardy problem to retry him on count 2. The Commonwealth had every opportunity, as Mr. Brown did, to appeal this, to litigate the judge's vacating order. Did not do that.
After the judge vacated the conviction in count 2, was there a resentencing?
No, the judge said there was no need. Actually, in the first motion, when the judge ordered it to be vacated, the judge's order said there's no need for resentencing because Mr. Brown it was a concurrent sentence, and so I think the judge's position was that it wouldn't have changed the sentencing outcome.
Okay.
But that's still a double jeopardy problem. A concurrent sentence is still a double jeopardy problem. It doesn't have to be a consecutive sentence.
So if we agreed with you as to count 2, but disagreed with you as to count 1, would there still need to be a remand for resentencing?
If you agree with me on count 2,
That there can be no retrial on
there's
count
no
2,
retrial.
but that count 1, the conviction
And if
stands?
I don't believe so because I don't believe there would have to be a retrial because.
I didn't say a retrial, I said a remand.
Oh, I'm sorry, a remand for resentencing. Yeah, I don't believe that would be the case because the judge, you could, and we could see if the judge would take that into account, but the judge seems to have indicated in his order that getting rid of count 2 would not change his sentence. So I would take that as an indication that a resentencing wouldn't be necessary, but you could certainly do that. Okay. I would have no objection to it. But count 1 is the logic that Judge McLennan applied to count 2, saying there's a requirement for a specific unanimity instruction, and that's a substantial risk of a miscarriage of justice. That applies equally to count 1.
We understand your argument.
Thank you, Your Honor.
Thank you. And we will now hear from the Commonwealth.
Good afternoon, and may it please the court. Laura Drone for the Commonwealth. And I would just also want to note that the victim in this case is present remotely for the argument as well. I ask this court to affirm the motion judge's order that the Commonwealth is permitted to retry count 2, the lesser included. The issue is whether it's duplicative and whether double jeopardy applies. In this case, retrial is not barred.
Do we know for which event or what conduct the jury convicted on count 1?
For count 1, we know that it was October 20th. Count 1 was charged October 20th.
Weren't there multiple instances of conduct that occurred on October 20th?
So there,
Was there only one alleged violation? Seems to me, I could be wrong, that there were a few different violations on that date,
I see. So
arguably.
it was on that October 20th date, it was excuse me, series of text messages, and then there were some blocked calls afterward. However, the identity was able to be proven for the text messages because the content of the text messages corroborated the identity. Or that's actually what proved the identity of the sender. However, the cell phone calls that were made afterwards, they weren't picked up, so there was no voice recognition by the victim to identify who the sender was. So there really is only sufficient facts to support one single restraining order violation from October 20th.
So I'm looking in the appendix at the verdict slip for the first for count 1, and there's no date on the verdict slip.
That's correct.
And then I'm going sort of laboriously through the transcript looking for the number 20, and my memory is from having done this earlier that there is no point at which the jury were instructed count 1 has to do with October 20th. Am I right about that?
So you're right that there were no specific instructions from the judge that...
In the pre-charge, they read the complaint, which listed that date.
Right. The charge from the clerk listed that date for count 1. However, the facts that came out at trial showed sufficient evidence for October 20th, if we're just referring to count 1. And the jury was instructed on the elements for each type, and then the openings and closing, each type of a violation of a restraining order versus the stalking charge that was instructed separately. And then with respect to count 1, the openings and closing statements did separate the conduct between the two charges, even if it didn't use the same language, stalking versus the standalone restraining order violation act. It used language that mirrored the stalking jury instructions to separate the two. So when there's
Let me
discussion
ask
of
you
a pattern.
this. You cite the Gauss case, 461 Mass, for the proposition that, quote, although the judge did not use the exact words, separate and distinct act, in quotes, he made it perfectly clear that the two indictments were based on separate acts. How here did the judge, in his instructions, make it clear, perfectly clear, as you say, that the convictions on count 2 have to be based on separate and distinct acts from count 1?
So here, it's combined, the judge's instructions regarding the two different types of charges illustrate that they're two different charges with requiring two different acts. That's also supported by the evidence that came in at trial and framed by the openings and closings.
How about staying with just the instructions? Where can I find anywhere in the judge's instructions that show me that it is perfectly clear that the conduct for count 2 had to be different than the conduct from count 1, that they had to be separate and distinct acts?
So that there was not...
Maybe inferable, but perfectly clear is what you say, so I'm going to hold you to that, okay?
Sure. And I think perfectly clear can be, not necessarily a specific instruction from the judge, but the fact that they're instructed separately, the fact that they're read the elements for restraining order violation and the volume 2 of 101, page 101, and then the stalking instruction separately, and then the lesser included of stalking separately as well, all between 101 and 104, that he instructs that the stalking is over a period of time, which implies that there needs to be a time range, a date range for the acts of stalking versus...
Stalking include the conduct from October 20th, 2021? The stalking charge, did it include that conduct?
So it did not include that conduct. And
Well, it
Jury.
did as charged. I mean, the complaint has the dates. Am I misremembering this? Doesn't the criminal complaint with respect to that count say October 20th to 21st?
so the way the clerk read the complaint on that day, that's correct, that it was
And
read.
the way it's written.
It's read on various dates between October 20th, 21, and October 21st of 21. However, the reading of the complaint is not evidence, and the judge did provide two specific instructions that the complaint itself is not evidence on
Right,
pages.
but you made the argument in your brief that it was, count one was clearly involved the conduct from October 20th, 2021. How do we know that? You cite to the judge's instruction in the pre-charge where they read the complaint. But now you're saying, but you can't look at that for the problem in the relationship between count one and count two.
Well, I think you can look at it, but it's a slightly different analysis based on the way the evidence came in. So the clerk read, and the variance between that, like Commonwealth v. Day recognizes that variance between the allegation and the proof isn't grounds for acquittal if all the essential elements are met. And the date itself is not an essential element here.
But while it may be true that the date is not an essential element for proof of a stalking violation, we're asking a different question. We're asking whether, I guess we're asking at least two different questions. One, whether we can say with confidence that there was no double jeopardy violation because of two convictions for the same criminal offense as to which the jury did not ever tell us what date the conduct occurred on. And two, whether we can be confident, and I think this is sort of maybe 1A, because it's definitely subsidiary, that the jury agreed when it convicted on count one as to which factual act the defendant had. This is a terrible sentence, but whether the conviction on count one can confidently be said to relate to a certain one of the pieces of evidence in front of the jury. I don't think that the reading of the criminal complaint answers either of those questions.
I think one thing that does clarify that question is the question the jury actually asked and the instructions that were provided there. They asked a question that shows that they understood the difference between restraining order violation and stalking because they wanted to clarify our multiple acts, or the way they phrased it was, does a restraining order violation require multiple events or multiple acts? I can't remember the exact wording, but.
Multiple violations required.
Violations, thank you. And that showed that they were specifically asking about a restraining order violation, they didn't ask about the stalking charge. And the way that the judge instructed them, he answered the question if it's about what's necessary to violate a restraining order. It is just one of the prohibited events. That was what we believed after, trying to figure out what the jury was asking. That's what we believed the jury was asking, whether it had to be physical contact, indirect contact, one of those. But the judge did also specifically tell them, if you're speaking, and this is from volume 2, page 127, if you all are speaking about the stalking issue, that's a different matter, and I can give you a different instruction on that. And then he told them, come back out and we'll clarify it, ask another question if this doesn't address the question you have. So it shows that they were asking specifically about the restraining order violation, whether that required multiple acts, and they were told, no, it's just one act for the restraining order violation.
And how can you be confident that the one act that the jurors thought was the basis of their conviction on count one was not the same act that could be the basis of a conviction if there were to be a retrial on count two?
Sorry, so if I can just clarify the question, is it regarding the retrial?
So let's say you say that it's clear, and we may or may not agree with you, but for the purposes of this question, let's assume we do. You say it's clear that the conviction on count one related to conduct on October 20th. Mm-hmm. How can you be confident at a retrial, that another jury would not again convict the defendant for a violation of a restraining order based on the conduct on October 20th?
So with respect to a retrial, because the retrial, we would not be using the October 20th incident. So because, at least my argument is that count 2 is the one where we need the retrial because of the lack of clarity about which restraining order violation was found, but count 1, there is clarity, so I would...
So the issue isn't looking forward, it's looking backwards, right? So it's to what extent can we be certain, or it's actually the language from Kelly that, thank you for the 16L letter, it's the language from Kelly that we have to adopt and say, it's, what is it, a reasonable possibility or?
Any significant possibility.
So if there's a significant possibility that the jury convicted on count 1 for something other than the October 20th, or it's possible, then there could be no retrial, correct?
Correct. So what I would point to there to answer that would be the content of the messages from the October 20th incident.
But what is the thing that ties the jury's writing guilty on the verdict form for count 1 to October 20th?
Sorry,
I understand you argue that the jury could have found, based on the evidence, that the restraining order was violated on October 20th. But if that is not enough under the law, if we need to be confident that they did find that it was based on the conduct on October 20th, what's the connection between that verdict on that indictment or complaint and October 20th?
So I think what illustrates that is sort of the opposition of the two verdicts that were rendered. So the verdict on October 20th, the language of the text messages referenced the October 18th incident. So the fact that they found a separate restraining order violation under count 2 on the lesser included that was noted in the October 20th incident, I think helps to sort of show the opposition between those two counts. The jury on count 2 certainly could have found, since the charge was stalking, they could have found more than one violation in count 2, but just not.
Do you agree that there is a possibility that the jury convicted on count 1, just a possibility, that the jury convicted on count 1 for something other than the October 20th, 2021 conduct? It seems to me it's possible, right? Your argument is that, as I understand it, but there's no significant possibility under the Kelly standard.
Right. There's no significant possibility. I think it would be not logical for the jury to have found something other than October 20th for count 1, because that one was charged not as a date range like stalking was. That one was charged as a specific date, and testimony came in that manner, that there were multiple dates over a period of time.
But the jury was never instructed that. I understand the charge, but they were never instructed that, correct?
Right. But we also presume, the jurors are also told to use their common sense as well. And the jury question shows that they were trying to figure out if one restraining order violation counted for 2 events, 2 acts. And they were clarified then in the jury question that they were not.
Let me ask you this, because I'm having some trouble understanding the Commonwealth's fervor to retry this individual. The defense cited the Jones case, Commonwealth versus Jones, and in that, the Supreme Judicial Court said, in a situation like this where you have multiple charges and there's a potential that the duplicative convictions, the court said this: the proper approach would have been to submit the charges to the jury, and if guilty verdicts were returned on more than one, to dismiss the less serious charge or charges prior to entering a judgment of conviction and sentencing on the most serious crime. So that would be the end. So I'm not understanding why the Commonwealth is suggesting that there can be another trial.
So I think what the court is addressing is sort of what's addressed in Commonwealth v. Gupta, where there's a conviction on the greater offense of stalking and a conviction on the lesser offense separately. And because there, they convicted on the greater offense, which necessarily could have included the lesser offense, there was that problem. But here, there's no conviction on the greater offense. So I think that's the distinction here that matters, is that it's two separate lesser offenses.
Any further? No. This is a very challenging case. It's been well argued, and the case is submitted. Thank you.
Thank you.
We're going to take a 5 to 10 minute recess. Calling the fourth case on our list, docket 23P419, Taylor v. Boston Teachers Union. And Attorney Jens?
Indeed. May it please the court.
Good morning.
Good morning. I'm not going to belabor the facts too much in this case, being that it's a motion to dismiss, but I do want to emphasize the degree of intrusion on the collective bargaining agreement that the motion that was promulgated by the Boston Teachers Union affected. It essentially substituted a medical status of the employees for a seniority-based system when it came to layoffs. It further waived their rights to arbitrate or pursue grievances, and it reduced accumulated sick time, accumulated at 100% of value, to 40% of value for those employees who were so-called unverified.
Are you talking now about the February memorandum
Yes.
of agreement?
And that's what we brought suit on initially.
And is this what it did or what it would do?
It's what it would do. Now, I'll confront the issue of mootness head-on because obviously the city or the school committee never signed off on this. I think largely in part because we served them a copy of this complaint, and then they tabled their motion and they never did anything after that. But in terms of mootness, if you go through the mootness...
Well, wasn't that a win for you?
Well, it was a delay. Who knows what lies ahead?
Well, I thought what lay ahead was the September MOA.
The September MOA followed on the heels of the February one.
Right.
And we
wouldn't it supersede it if the school committee were to adopt a memorandum of agreement?
Well, we could speculate about that, but I submitted it as a supplementary pleading just to show that the union management had been for quite some time and was continuing to promulgate these measures without complying with the bylaws of the union requiring written notice and a supermajority vote. Obviously, it wasn't as severe as the previous one, but it still required testing and other types of obligations, medical obligations on the part of the employees, none of which appear in the collective bargaining agreement.
Before you get to mootness, let me just make sure I understand something. The February 2022 MOA never went into effect, correct?
Well, it went into effect in terms of the internally within the union. They passed it as a motion, signed off on it, and submitted it to the school committee where it sits to this day.
Right. But it's
And
never been effectuated. How's that?
That's true.
How about the September 2022 MOA?
That appears to have been effectuated, and I think, and I'm going outside the record here.
Well, that's the problem. We have to go by, so don't go outside the record.
Okay.
At least as far as the record before us indicates, there's no indication that the September 2022 MOA was effectuated.
Let me put it this way. There's no indication since this case was decided below what the status of that effectuation is.
On the record before us, which is
Yes.
what we're bound by, unless it's been supplemented.
Yeah.
There is no indication in the record that the September 2022 MOA was effectuated, as far as on the record before us that we have. Is that correct?
It may be in accordance with the record before you, but the ones before that preceded it that were very similar, in the record, they were effectuated.
Okay. So let me ask you this. You're using the term mootness, and it seems that the terms in the brief, ripeness, mootness, we're in the context here of the Declaratory Judgment Act, General Law, Chapter 231A, correct?
Correct.
So the issue before us is whether or not, I believe, is whether or not there's an actual controversy within the meaning of the statute. Yes?
Yes.
So when you're using the term ripeness in your brief, what you are referring to is whether or not there's an actual controversy under 231A, right?
Yes.
Okay, that's very helpful to me. So here's my question for you. In your brief, which is very helpful, in your brief at pages 29 to 31, you cite a number of cases, a U.S. Supreme Court case, some First Circuit cases, which seem to me to stand for the proposition that in a situation like we have here, we, the appellate court, have the discretion or the power to decide the case under 231A.
Absolutely.
But none of those cases stand for the proposition that we have the obligation to do so. Is my reading correct?
As far as it goes, but there's a distinction between this case and virtually all the other mootness cases that I could find. And that distinction is whether or not this was implemented, or harm is taking place, or a controversy takes place. In the cases that have found mootness, or have found it not moot because they decided to use their discretion, the reason that behind it is because the defendant authority rescinded or repealed what they did. Now it's moot. It didn't depend upon the whims of a third party. I'll give you an analogy. Let's suppose that I were a mischievous sort and I managed to get a copy of the keys to your front door of your house, and I'd come over, unlock it, and leave the door wide open. I repeatedly did it. Could I defend by saying, well, no third party has come in and robbed you? The sword of Damocles is hanging over you. And it hangs over to this day. It's never been rescinded. It's still out there. And using this procedure that we complain of, other type of things could be hanging over these union members who paid dues for these rights, who paid dues in support of having these bylaws as protections.
I'm going to ask you about that, but I want to go back. I need an answer to my earlier question.
Okay.
Under the authority that you're relying upon, would you agree that it's correct to say that this court has, your argument is, that legally we have the discretion, jurisdiction, and ability to decide this case, but there's no authority you have for the proposition that we have the obligation to do so here? Would that be correct?
I think it's correct for some cases. I don't think it's correct for this one, and here's why. For the first is the issue that the determination of whether any controversy is going to happen isn't between the parties. It's from a third party. And the second is that the harm that we complain of isn't just the harm that would happen if this measure were implemented. It's the degradation or abandonment of the rules of institutional governance.
So what is tell me with great particularity, what is the actual controversy in this case within the meaning of General Law, Chapter 231A?
Whether the union management is bound by the provisions in its bylaws requiring for them to bring a motion or an amendment to that changes the rights under the collective bargaining agreement, to proceed that with a 15-day written notice and then follow it up with a supermajority vote of the membership. And there's no dispute. They didn't. They abandoned it, and they presented it as a motion at a meeting, and it's in the record that the only notice for it was they were going to talk about Black History Month and some spring picnic or something. And 300 members out of 8,000 attended, and they say, oh, we want a supermajority. Well, it's not that hard to do if you don't give notice of the measure.
So
it's
what's
that
the harm
procedure
here? So the harm here, you're saying, is that these union members, these plaintiffs collectively bargained for certain rights, and those rights are being ignored in this context or being violated.
Yes. They've abandoned their governing principles of their institutional governance. I could think of analogous situations for, say, in a corporation with shareholders and things like that. If they started appointing members of the board without consulting the shareholders or passing resolutions or measures.
Right, but the problem, I shouldn't say the problem.
Challenge.
The concern here, challenge is good too. The challenge and the concern here is, for example, two parties have a contract.
Mm-hmm.
One party does an action which they don't think violates the contract, but it arguably does. And the other party comes over and says, hey, look at the contract, you can't do this. And they don't effectuate then the violation. you understand what I'm saying?
If it were just the two parties, I would, agree with you. There's a problem.
Typically, we wait to make sure there is a concrete harm of some sort that is not speculative, that is not contingent on the violation being effectuated.
Let me alter your analogy. Let's suppose that we have a contract, and one of us makes unilateral changes to it, and does it again and again and again, and a third party, all for the benefit of a third party, requiring me to supply widgets at a certain price where I didn't have to under the contract. It's no longer, the harm issue isn't just whether the third party takes advantage of me. It's whether I can rely upon my contract, not just now, but moving forward.
Did you seek injunctive relief initially?
No.
Okay.
We just sought the declaratory relief.
Isn't that, though, the remedy usually for something like this? Okay, they're violating our rights, and if this goes into effect, we're going to be seriously harmed. So you run into court and try and get a TRO or an injunction and say, so that the court can say, union, knock it off.
If this were an injunction application, I would be more inclined to agree with the opposing point of view because I would have had to show immediate irreparable harm. But you can be harmed without it being immediate or even necessarily irreparable, as in your contract example. I think that this is substantial rights of this union membership. It goes to the very heart of what a union actually does. And the union management abandoned these principles and essentially gave away the store to the city. Other unions didn't.
So before you do, what is your very best authority for the proposition that the conduct at issue here constitutes an actual controversy under 231A? Your best case?
Best case is whether the union management, not
your
just...
best legal citation, legal case, legal authority.
Okay, we did attach a case to the addendum in the brief. It's out of Michigan, but it's very, very well reasoned, and it's...
I read it. It's helpful. What's your best Massachusetts case?
I don't have a Massachusetts case, but I do have this case here, and it involves coronavirus, and it is an excellent articulation, with a dissent, by the way. It was a split decision by the court, but the majority found that the vindication of rights is a necessary one to the health of a democracy. Now, that was a dispute with a governmental agency.
This is the T&V Associates case, right?
That's right.
Yes.
This here is a private dispute, and I mentioned in my reply brief, which I vented a little bit there. You probably saw it because I've been litigating these things for quite some time.
Now, let me ask you this before you run out of time, because I think this is important on the issue of remedies, because I have to say I'm sympathetic to your argument in that, if I understand it correctly, you have the union leadership basically doing an end run around the union membership here. That in these memorandum of agreements, there's a danger there in using these, because what can happen is union leadership on the more difficult questions that maybe they think they can't get past the membership, they punt on those when they're negotiating the CBA, and then they enter into these memorandum of agreements thereafter and avoid having to submit everything for ratification under Article 10. And if that's what's going on, that's clearly not healthy for the democratic process of the union. But I'm wondering, is it the role of this court to remedy that, or should it be the people who are aggrieved by it to go to the union and to get the bylaws amended to make clear that certain subjects cannot be made a subject of a memorandum of agreement, or set up a process to make clear that, this all has to be part of the CBA and it has to be all voted under Article 10, just to clear up this ambiguity.
Well, I'm in agreement with you, except that I already think it's pretty clear. In other words, if it changes your terms of your collective bargaining agreement, and this plainly did, then they have to pursue a prescribed procedure. They didn't. They abandoned it, and they abandoned it over and over again as they made the record out to be. So that is the harm right there. They can't depend on their union anymore. They're not getting their money's worth for their dues. There are people who had to take early retirement to avoid the consequences of this because they thought it was going to turn into a controversy, et cetera. I tried not to bring this as an injunction or a breach of duty.
Your time is up, but I'm going to give you another minute. Please go ahead.
As a duty of representation case, because I want to pursue the purpose of a declaratory judgment, which was to avoid that nasty legal controversy, get some guidance from a court. Here is what the proper way of abiding by your bylaws is.
Anything further? No. Thank you very much. And Attorney Goodwin?
May it please the court. I'm on the back end of a cold, so if I lose my voice a little bit, just please tell me to speak up. First of all, there's the union management framing in and of itself is objectionable to me, and I have a great deal of respect for Attorney Jens, and we get along, but these are all duly elected officials of the union. These are not some sort of union bosses. They entered into all of these agreements with a great deal of transparency in a period of time that I will remind everybody was absolutely brutal on the school system. So context does matter. But the notion that we gave away the store or that this was a declaratory judgment because, a TRO wasn't appropriate or a DFR wasn't appropriate, it's incorrect. A DFR wasn't filed because it would have lost. A TRO would have filed because it would not have taken ground. This is a political case. This action is being brought against this union because it decided that the city probably had the ability to mandate vaccination in the beginning of the winter.
Were the 15-day and two-thirds supermajority requirements not required here?
Because they've never been required outside of a successor collective bargaining agreement. The Article 10 of the bylaws has never been read in that way. My law partner has been practicing with the BTU since 1987. They've never been interpreted in a way. That Article 10 applies to this document. This is the 200-page collective bargaining agreement, what in union parlance would be referred to as the main table agreement. If every agreement that the Boston Teachers Union entered into with the School Committee of Boston were to require a two-thirds supermajority vote, nothing would occur. Every time the grievance, an extension on a grievance was provided. Every settlement agreement for a discipline case. If somebody...
But to be fair, those examples don't touch the daily experience of teachers, union members teaching in the schools the way that this February 21, right? I mean, I'm not diminishing their importance as to the particular teachers whose issues are considered by those, but I think what your brother is saying is this changed the conditions of employment for my clients.
It's impacting the terms and conditions of employment, which is the obligation under 151E for all collective bargaining agreement. And it is, you cannot distinguish between the main table agreement and all of these other agreements, because for one person who gets fired and we entered into a settlement agreement, boy howdy does that have an impact on the terms and conditions of employment. More immediately than any of the plaintiffs or appellants in this case, because none of them lost their job because of the actions of the Boston Teachers Union. So I understand your point that yes, it would seem that some memorandum of agreements, for removing from this example, say special education services or, ABAs giving kids certain type of services on the spectrum at this point, or speech pathologists doing this. But we enter into those MOAs all the time. Yet they're not brought up here. And they're not brought up here because this only has to do with COVID. This is political and it is academic.
Okay, but so let's just assume you're right about that.
Sure.
I have no knowledge one way or another. I know you're sort of arguing from experience, which obviously none of us have, that this isn't how it's done, but why does that mean it's not how it should be done?
Because labor relations is archaic. If you take, there are 150 schools. There are 54,000 students, and we have approximately 10,000 members at any point in time. If anything that impacts the terms and conditions of employment, if Article 10 were read in that way to require a supermajority in a 15-week notice, then a small agreement, medium agreement, big agreement would have to go to the union. And that's just not how it's been done. And if it can't be read that way, it would freeze labor relations in the Boston Public Schools. And yes, if your point would be, is it wouldn't be better if it was articulated probably before I was born in these bylaws that it was successor collective bargaining? Yes, that would be clearer, and that probably would be more helpful. But within the realities of 150E, it is the only reading that functional reading.
So assume for the moment that this, the challenged MOA had nothing to do with COVID. Assume that instead it was an agreement that teachers would have to work until July 4th every year. Would that require the Amendment 10 process?
Well, the school committee sets the calendar, and then the payment comes within it. So it's
But
not.
my understanding is
I
the
get.
school committee sets the calendar under substantial influence from the union.
To some extent, but that is, again, now we're getting back to the larger point here, because that goes to delegable and non-delegable rights.
You're not distracting me. I still remember that I asked
Yeah,
you a
yeah, but
question.
I'm just trying not to be. But it's important, because impact bargaining and daily negotiation is very different than this document. It just is. That's just how the reality of of 150E works. And the language in Article 10 is designed about ratification of the main table document. This document, unlike the agreements that you're referencing, right, requires the school committee of Boston to strike that. The city council of Boston to fund it. They didn't have to fund this COVID agreement. It's a more formal structure, which externally, if you're not in this space, you would think that, yes, well, it alters and amends. But everything a union does and every agreement they enter into with the school department, which we're talking about thousands of years. We're not talking about 1 a week, 2 a week. Since this period, I'm not sure how many MOAs have been entered into, but my office is at least 200 to 500 active matters with the BTU, and we don't even do all of their work. So all of these things result in agreements, and they do not require a supermajority decision. It just can't. And I understand the argument, but the notion of it, but when you just strip it away to how this all works and the realities of 150E.
But isn't there a danger of abuse here? That if you have leadership that does really not want to, face the union members on a particular issue, that you can avoid, let's leave that out of the CBA, and we'll address that later in an MOA.
No, not really, Your Honor, because the duty of fair representation is real, and they're elected every few years. So this is a democratic union. It's a union that really has prided itself on bringing people in. And in fact, these virtual meetings, we were having meetings about the COVID, the COVID policies, COVID updates. I was on for this period of time, I don't know how many, but dozens of such meetings. And we're giving updates, we're communicating to the community. The idea that we did some sort of end run, we had this document on February 9th and the membership saw it on February 9th. Like, I don't know how much more transparent we could have been. And then we contingent it despite, and the very February document demonstrates my point here, because we said in that document it had to go to the membership. We said that because we didn't have to do it, but because we knew that it was such a political fraught thing. That is why we invited them in. We did not do this to harm Attorney General's clients. We did this instead to make sure nobody lost their job, because the firefighters in the police case was a loser. And we had to deal with a very difficult situation, and now the appellants are trying to punish us for the decision of the city, and we are not the party that should be here today.
Well, but you are. So let's get back to the issue of ripeness. When you use the term ripeness in your brief,
sure,
you're speaking to the actual controversy requirement of Chapter 231A,
Yes, sir.
yes?
Yes.
Okay. As I understand Mr. Jen's argument, in part, it is that these are not uncertain and contingent events because there was a non-contingent, very real harm done to his clients, which was their rights to the 15-day notice and the two-thirds supermajority were violated. With that argument in mind, explain to me, or to us, why, in your view, there is no actual controversy here.
Well, to the February agreement, it just was never signed by either party. We had the vote, the appellate court was going on. One of the other contingencies in that agreement was that the stay of the appeals court, or the decision of the appeals court, it would hold until that resolved. The appeals.
Assume for purposes of my question.
Sure.
That there was a violation of the bylaw. I know you insist there was not.
Oh, no, I understand that, sir.
Assume that there is.
Yeah.
Why is the violation of the bylaw and the loss of those rights not an actual controversy, just because it didn't go into effect?
The February agreement never was executed. It is dead on the vine. It never took place because of the.
But you understand that Mr. Jens's argument is that, right, but you did it again in September, and you could do it again and again and again. And just by not effectuating it when you know you might lose.
Well, September is very different. So I don't think that is the argument, because I think that much the opposite, Your Honor. I think this is the very nature of an academic argument. It's like, well, what if it does happen? That is what academia does. You're thinking it out. It's like, well, where does this go? Maybe this could happen. Well, it didn't. And that's where harm is. You can't, there is no harm. Nothing happened to them. Now, going to the.
Or if it is, it's uncertain and contingent.
I can speak pretty frankly, that agreement's never getting executed. So it's done. That we'd have to renegotiate. There's been we're under a different collective bargaining agreement entirely at this point. So that is all, it's dead. So there's no academic, we would have to renegotiate it. Everybody would know we'd be renegotiating it, and it really wouldn't make sense within the COVID climate right now. But going to the September agreement, that is a operational document. That is a policy that the district issues. They send us how they're going to open it, the school district, and then we go through and say, hey, are there enough gloves? What are we going to do at this point? How are we going to verify?
There's no indication in the record that it was effectuated. I'm asking you to stay within the record. Within the record, there's no indication the September.
Well, but it was, in fact, the same agreement from the year before occurred, as Attorney Jens had said, and I don't think there's a dispute, that we were entering, I think there's nine COVID agreements. Yeah, and we were coming in to make sure, nurses had gloves. That would not require a supermajority vote in any union setting that I've ever been around, and I've been around a lot. And the larger kind of point about is that, and the introduction of that September document was after my motion to dismiss, when it was demonstrated that the February agreement was not being executed. So,
What's your best case for the proposition there's no actual controversy here? By best case, best legal authority, preferably a Massachusetts case.
It's just a statute, Your Honor. It's plain. It's just right on the face. I mean, this is the type of thing that doesn't almost get analyzed because it's what it says.
So you're going with it is clear beyond peradventure, that argument?
Pretty much, yeah.
Do you have anything further?
I could go on and on, but I don't think it's helpful.
Thank you both. This is an interesting case. We appreciate the briefing and appreciate your arguments. Thank you. The case is submitted. Next case, docket 23P110, Doe v. Sorb, Doe v. Sex Offender Registry Board. Before we begin, counsel, please keep in mind that this case is impounded. Please refrain from using any names of the parties or referencing any impounded material. Mr. Burkholder, it's good to see you.
Good to see you, Your Honor. Good morning, Your Honors. May it please the Court. I want to read you something, because this expresses my sentiment of where this case is. This is a paraphrase of a comment or dicta that is contained in DO 523722. And it says,
I think I have familiarity with that case, but go ahead.
it basically says this: we have a hard time conceiving of a circumstance in which one who has committed a violent sex crime.
No, you have to read with more passion if you're going to read. A little more drama.
All right. We have a hard time conceiving of a circumstance in which one who has committed violent sex crimes against children like those at issue here, even in the distant past, can ever be found to have anything lower than a moderate risk of reoffense and thus warrant a level 2 classification, barring perhaps attainment of extreme advanced age. That's my case. I mean, my guy is now 65. He was, 62, I think, at the time of our hearing. Where is it? You know how old his offenses are. You read my brief. I mean, the question becomes, at what point, and I think my brother kind of outlines what's necessary, and that is this. He cites a quote from DO 524553, which basically says the court would have drawn the same conclusion as the board, but only whether a contrary conclusion is not a merely possible but a necessary influence. Inference. So here's the point. The point is at some point, I think it's incumbent upon our courts to rein in the amount of discretion that exists in the board.
In a vacuum, I agree with you. Do you have a question?
I do. I found the briefing on this case on both sides to be very interesting because it seems to present the not unusual but kind of extreme version of a question that comes before us not infrequently in these cases, which is if someone's been incarcerated for a while or a time, or in this case, a very long time, and so the only sort of roughly contemporaneous or even new-ish evidence of that person's behavior, adjustment to society, willingness to participate in treatment, support in the community, likelihood of offense, you can kind of tick through the factors, is either probably or arguably not informative because it has to do with a very different setting, namely prison, or extremely old. Where does that leave the examiner? And unsurprisingly, each of you comes at that from a different perspective from the other. I'm going to ask, I guess, each of you this question. What is the solution? Is there a point, would you argue that there's a point at which the passage of time alone means that the earlier behavior can't be given substantial weight?
No, I think that the answer that I would provide is, and it comes from DO 24341, which was the case which all this is based upon, which says the hearing examiner has to indicate a predictive value from those offenses. And that's what's lacking in this case. There is a narration of a lot of bad stuff because, frankly, nobody's going to argue with it. But it happened 30 or 40 years ago. So the only thing that, Your Honor is right, the only thing we have to look at is behavior while incarcerated. I do SDP classifications and appeals, not classifications, but the appeals. They want to extrapolate, in those cases, they want to extrapolate from the conduct before and look forward based upon what occurs while they're in the institution. They look at D reports. If you correspond that to this case, my guy hasn't had one in 20 years. They look at participation in sex offender treatment, and that becomes a whole nother ball of wax to examine. But the studies that come out say, certainly participation in treatment reduces risk, but correspondingly, the failure to participate does not increase risk. And that's kind of what I feel that this decision does. It penalizes him because he didn't want to go sit through sex offender treatment program classes, nor did he want to sit through CRA, substance abuse program. But it's like in those cases that I was just referencing, the proof in the pudding is, so did he do anything? And many of those guys in that setting, which are also the clients that you face in these, they've either said something inappropriate to someone of the staff members, or they've been caught acting inappropriately with one of the people, other inmates, or they've been observed doing something. None of that happened here. My guy has done nothing wrong for 20 years.
So you're not relying so much on age as you are the number of years?
I'm relying on all of it. I mean, here's...
Well, the reason I ask that is because we have a case, argued by Attorney Shania, unsurprisingly, but we had a case involving a 74-year-old, a defendant who was 81 at the time of the classification hearing, who committed a terrible sex crime at the age of 74 or 75. And I've been hearing for years, well, at age 62 or 66 or 70, he's way too old to offend, it's not going to happen again. Then we have that case. Now what do we do? So to me, age is not necessarily, it's a factor, but it's not necessarily the end-all, be-all.
Exactly, and I totally agree with you, and I didn't even go there because full weight has been assigned to it under this decision, and therefore, because no study, I didn't try this case, so no studies were introduced with regards to the effective age and a cutoff at 70 and the reduced risk and the like. I didn't go there because that's not the evidence that I have to work with.
Right.
What I have to work with is this. Here's what my problem with this case is, other than what I've already said. But the hearing examiner really didn't know what to do and how to address these things. So she kind of picked and chose. And for instance, and I mentioned this in my brief, so I won't belabor it, but she looks at factor 11, which is prior violent offense. And she says the last one was in 1991, and as a result, I'm going to give it minimum weight. She looks at behavior in the institution, and she looks in the last conduct was in 1997, 20 years ago, and she says, I'm going to assign no weight. But then she goes to factors 9, substance abuse, despite almost admitting he has sobriety, and says, it's too speculative, so I'm going to give it full weight. And she goes to factor 10, which is the criminal conduct, and says the same thing, because he has a history of persistent disregard for the rules. You want to tell me how 20 years with no D reports in a penal institution is characteristic of persistent disregard for the rules? I mean, spare me. How many people walk through those institutions without getting an armful of them just because of the people they have to confront?
But, I mean, I think that goes back to my question about how long it's been since he was in a setting that more reasonably approximates the one into which he is about to be released. I mean, my memory is that finding of hers was based on the fact that both index offenses, which were separated by many years, occurred when he was on probation.
Correct.
So it's one thing to say that someone, and it's not nothing, don't get me wrong, that someone can comply with prison rules for decades. I mean, that definitely says something, and I think the examiner acknowledged that. But that's not the same thing as saying, and he's going to be compliant on the outside.
I don't disagree. And I think that's where I don't know how to answer the question or provide a system that would account for that. But I know this much. I've got a guy out there that did almost 40 years in custody that's walking around with a level 3 that did everything he possibly could in the institution to stay out of trouble, and he can't find housing because he's a level 3.
Yeah, but you know what? There is some logic.
Now let me, if I may, I'm sorry.
There is some logic to this, because, you know, when he's in the institution, it's not just that he's in a controlled environment, but he's in there with all males, and his offenses were against females, vulnerable females, in the dead of night. So this is for the first time in many years, he's back in the community where he's going to be around vulnerable females in the dead of night. So doesn't it make sense that the examiner should be, you know, carefully looking at all these factors in that light? It's not just he's in, he's out. It's all the circumstances that surround it that are really relevant, including like substance abuse, where, well, he's less likely to have a chance to abuse substances when he's locked up, but once he's out, it's all bets are off. So it seems quite logical to me that the examiner is going through this in a very methodical way.
Yes, but, and the but is this. The decisions allow for a hearing examiner to adjust the degree of weight to assign to each factor based upon the age of their offense. That's all I'm asking for. I'm not asking for him to be a level 1. At a level 2, he's still going to be on the internet. He's still going to have the public is still going to have the same protections that are available. But the impact that a level 3 has upon these guys is unbelievable, because you can't find a place to live. Even the housing authorities can't find a place for them to live. If they're a level 2, they can. As soon as they become a level 3. So here's, and I didn't mean to interrupt you, and I have tremendous respect for this court. I'm here all the time. Here's the problem that I have with my guy. He's going to call me later today, and he's going to say to me, Fred, what am I supposed to do? Do I have to be 70? Do I have to be what? And the court may look and say, well, why hasn't he applied for reclassification? Because he hasn't been out for 5 years, so the same factors are in existence now. So what am I to tell the man? Am I supposed to tell the man, you've behaved for all this time, and yet you're still a level 3 in the court's eyes because a hearing examiner sat over there and said, well, I think that you're too much speculation. I think there needs to be some middle ground. I totally agree with protecting against risk. I have members of my family I want to be warned as well, just like I'm sure everybody else does. But you've got to look and say at some point is enough so that they can still conduct their lives. I mean, when I used to try murder cases with Barry Wilson, we'd get guys that got ABDWs and they got 10 to 12, and when they walked, they were done. This guy's got 40 years. 40 years. And he's still paying. So I don't want a level 3. Give me a level 2 and let him get a house.
You're concerned about the, sorry to interrupt you. You're concerned about the application of the factors here. I found interesting. Here, the hearing examiner, with respect to some factors, gave it full weight, gave it some weight, gave it minimal weight, gave it moderate weight, gave it no weight. With respect to other factors, the hearing examiner simply said, I find this factor applies. Where does that come from?
6729 in the Supreme Judicial Court. That's the case that Ashley Green argued with him, and she lost. And it said, now there's no need to indicate any specificity, and that's an argument I totally and completely agree with, and I know where the court's going.
But how does the, how?
But I can't make it.
I'm aware of the case, but how does that make sense in the context of cases where weight is applied to various factors? How is there a calculus if you just say, well, this one applies? So in other words, if a hearing examiner says, I give this full weight, well, there's a risk for the hearing examiner to do that, because if we disagree or find that the record doesn't support that, the case gets sent back. If you just say this applies, our review is limited. How does that make sense?
Let me give you an example. Say I wrote a brief, finished it on Sunday. There is an application of a factor with regards to substance abuse. It simply says applied. There is evidence that the guy's been sober for a number of years and participated in treatment. The hearing examiner in the decision says there's no evidence of that. But when I argue it, what am I going to hear? Well, all he did was applied it. So therefore, he didn't assign full weight to it, or he would have indicated it. It's just a backdoor out of the fact that they can ignore things and do as they please. I have empathy for these guys because you can't pick and choose. The case law says you can't, and this decision is I couldn't give you a better example. When you say the same conduct in the institution, no way, and you say, what was the other one? And minimal with respect to violence, but yet the same conduct, the substance abuse, and how can you say criminal conduct has full weight and non-sexual violence has minimal? How does that make sense in my Middle Western brain? Because it doesn't. I don't think I have any further, if there's any questions.
Let me see if there's any further questions for you. No, thank you very much.
Thank you.
If it pleases the court, I think we might have hit afternoon, so I'll say good afternoon. David Chennai for the board. I would start by saying I think I've argued too many of these cases, but the...
Do you understand my concern with this applies without more when the
Right.
other factors are being given a more specific weight of some sort?
I think I addressed that in my brief, and really what it is, there's certain factors that can be applied at differing weights. In this case, there were the ones that were applied at differing weights. The hearing examiner did say what weight she was giving them. Certain ones, like factor 8, its application alone is evidence of a high risk or danger. And I would get back to Justice Hershfang's concern. How the factors work is the static factors, which are the sex offense factors, their impact doesn't necessarily reduce just because time elapses. How they reduce is what happens during that elapsed time. Does the offender start having personal circumstances that are positive in nature that reduce that risk? And this case is a good example of that. The hearing examiner looked at the sex offending behavior first. It was what she should have done. Then she looks at other risk-elevating behaviors that the offender engaged in. And then she looked at the risk-mitigating factors. And those are the dynamic factors that can reduce the impact of the high-risk factors, even the dated risk factors. In this case, the hearing examiner didn't find too many. She found age at full weight, but didn't feel that was enough to reduce the ultimate risk and danger. And I say that because with these incarceration cases, there are things that can be done by the offender while they're incarcerated. This hearing...
Offender treatment, substance abuse treatment, et cetera.
Right. This hearing examiner actually set a second day of hearing close to his release after making the initial level 3 to give the individual a chance to put in any updated information that would show that there's been more positive impact by his programming. And again, what the hearing examiner found was even with that additional time, he still refused sex offender treatment. He still refused alcohol and substance abuse treatment. But more importantly, his programming was such that it didn't indicate that he was taking courses that would help him integrate into the community, into society. And that's important in this case because he didn't bring in individuals who said they were going to support him. Like I've had a case recently where the individual had a number of family and friends who were going to support him when he was released. He had 2 programs that work with inmates when they're released to help them integrate into society.
Is that the case we heard last week with you?
Yeah, that was last. I can never remember which ones are which. But yeah, so there were things he could have done. And those are the things that would have reduced the risk. And if he had done that, he might have been a 2 in this case. And if he had done enough...
Just to take the sort of the question of the programs, what do you say to Mr. Burkholder's comment about those programs, that while it may be that statistics show that taking them can diminish the risk, there's nothing that shows that not taking them increases the risk? I mean, listen, I get it. You know, there are things that I'm sure every lawyer tells clients to do to maximize their chances of getting a lower classification when the time comes, and I also get it that not every client is going to do all of those. To the extent that it's could be perceived as, and I'm not saying this is what it is, ticking boxes or going through the motions, why is it appropriate in the weighing of his behavior while incarcerated to sort of give greater weight to his failure to take those programs than to his ability to spend decades behind bars with no disciplinary reports?
I think the actual sex offender treatment is different than the other programming. Factor 24 specifically says an offender who's incarcerated and is recommended that he do sex offender treatment and has the opportunity to do so and refuses has an elevated risk and danger. And that's the factor that the hearing examiner has to follow. And the reason I say that is because under Doe 10-800 and many cases, the factors have the they're the same as having a statute. And the hearing examiner doesn't have the authority to question the constitutionality or the validity of the regulation that they are implementing. So once he refused the treatment, the hearing examiner had to apply 24. Now,
Is factor 24 than a major factor here in this case?
You know, it is in the sense that it affected the hearing examiner's consideration of his possible stability, future stability in the community.
Right, but the hearing examiner just said, I consider this factor. Why not give that full weight?
Because that one there is automatically an increased risk or danger. It's not like factor 32 sex offender treatment where you get higher weight for completing it and lower weight for just participating.
But I'm fairly certain I have seen hearing examiners with respect to factor 24 give it some weight, moderate weight, full weight.
I personally haven't seen that. If I'd seen it, then I would say that they were probably, if they gave less than full weight, they were given a benefit, probably an unwarranted benefit to the offender. Because once he says, I'm applying a factor that its application alone sets the weight in danger, it's being applied at full weight. Because that's what the factor says. You apply this factor, it's increased risk and danger.
It seems to me I've seen in the context of attended some sex offender registry, some sex offender counseling, but continues to deny his conduct or something to that effect.
Right.
And
That goes to factor 32, which says that participation is a risk-reducing factor, but denial can lower or mitigate the weight given to that factor. It doesn't obviate the factor, but it can mitigate some of the weight and lessen the impact of the factor in the analysis. And again, that's a factor, and that's how it's written.
You had said earlier that if just one of these factors had cut the other way, I can't recall now which one it was you said, it could have resulted in a level 2 classification instead. But this is what kind of concerns me, and I know we've had this discussion before, because it could make a difference to the examiner, but then again, it might not make a difference to the examiner. And I think that goes to the point that is being raised here by your brother, that although, you know, there's this sort of kind of somewhat rigid, almost mathematical process set in place to do this evaluation, in a way it's almost kind of a veneer that doesn't reflect the reality of what's going on, that there is such wide discretion. You could get 2 examiners seeing the exact same case, and they're going to come up with different conclusions, different classifications. What do you say to that?
I would say it on 2 levels. First of all, the reason why we have this process where there's discretionary authority is because Massachusetts, through its court system, has developed this. Originally, we followed the Wetterling Act and the Megan Act, and follow what most states were doing, was pretty much giving a numerical value to things and then saying that you come out with a number, and that number is what will develop your risk. Most states just use a number system. If you've committed a certain type of crime, you get a 5. If you haven't done sex offender treatment, you get another number. Massachusetts, that statute was struck down, and in 2004, this statute was created, and part of it was to give, what the court wanted at the time was a system where all the circumstances are considered. But when you do that, you're going to have discretion. I think we had discussion last week. That discretion causes different fact finders to look at evidence differently. And that happens in district court, it happens in superior court, it happens in most types of agencies. The thing that this agency has, though, is one, there's superior court review to make sure that it was done properly. And then there's appellate review to make sure it's done properly. So, and this court can sit de novo and say, wait a minute, we don't agree with the hearing examiner's analysis on that. So those are the fail-safes of trying to rein in the discretion that's being used. If you find a hearing examiner's discretionary authority was beyond the beyonds, then you just say, no, we're not going to accept this decision and send it back with your concerns. That's how the system would work.
Well, but not really, right? Because we review to determine whether there was substantial evidence in the record to support the determination, and we defer to the expertise and technical knowledge of the hearing examiner. So none of that sounds like de novo to me.
Well, what you have the authority to do, again, and this is the whole idea of the discretionary issue, if you feel that a hearing examiner has made a decision or applied a factor that's not supported by the substantial evidence or is arbitrary and capricious, you have the right to strike that down. And that's really where the discretionary authority finds some limitation, because there is different levels of court review as to the discretion that hearing examiners are using. Now, I agree. There are different levels of discretion based on decision-making based on certain hearing examiners, just like there is in any court. I've had cases that I've scratched my head over, and I've had, on both sides, I've had 2s that I thought were 3s, and I've had 3s that I thought would be a 2. And I've had 1s where I thought that they were going to be, they were going to no longer have to register. They were going to terminate the registration. And in those cases, I try to get the Superior Court judge to go along with my thinking. It doesn't always work, but I try to look at it and decide, do I want to argue this case in the appeals court, which gets back to the whole violation of the discretion, because, again, if someone should be terminated, it's my belief they should be terminated. The whole idea of the Sex Offender Registry Board is not to prosecute these individuals. It's to find what's fair. And if someone's a 3 and they should have been a 2, that's not fair. But if someone's a 2 and they should have been a 3, well, they got a benefit, probably to the detriment of public safety. And that's really the gravamen of sex offender registry. And what I deal with, as you know, many, many days. So unless there's any further questions, I think I've briefed this fairly well.
No, the case is submitted. I'd like to thank both counsel. Well briefed, well argued. These are difficult cases, and it's taken under advisement. Thank you.
Thank you.
Calling our final case, docket 23P824, Department of Children and Families versus Mother. Council will be reminded that this case is impounded. Please do not use the names of any of the parties, the children, or reference any impounded material. And we will hear first from counsel for the mother, Attorney Curtis.
Yes.
Good afternoon,
Thank
sir.
you. And may it please the court, Robert Curtis for the mother. When terminating mother's parental rights in this case, the trial judge expressly identified a combination of 4 factors. And he expressly stated that these were considered in the aggregate with no factor being conclusive. Now, while mother has issues with all 4 of the factors the judge considered, there's one in particular that really should jump off the page, and that's the judge's reliance on mother's possible substance abuse disorder. And because a possible substance abuse disorder is certainly not going to be enough to warrant a finding of unfitness by clear and convincing evidence, I think the entire judgment at this point becomes suspect, because somewhat like a stool where all of the legs need to be supporting it, once you take one of those legs out, and we don't know which other legs were stronger because the judge said that he looked at all of them in the aggregate, the stool cannot stand.
And I want to ask you about the record here. I take your point that the judge did use that phrase, and it's, it's in the record, it's there. It was undisputed, and in fact, I think your client honestly and frankly admitted on the stand that she had been taking Suboxone for, I think, 13 years at that
Correct.
point. Suboxone is prescribed for people who have an opioid addiction. How is that not a substance use disorder?
Because that's the treatment. I mean, I'm not a medical professional, so I can't say whether somebody can ever be cured. But the problem when she was struggling with using the substances was from 2002 to 2009. Since 2009, she's been following her treatment protocol. And there was no evidence that the treatment wasn't working during this time. There was no evidence that she was going back to taking the opioids despite the treatment. So I think you have to view it that way. I mean, this may be something that she's going to deal with for her entire life. Again, I'm not a medical expert. But are we going to say that any parent who at one point in their past had a substance use disorder, and now they're following the treatment protocols, they're unfit? We can't say that. So that's certainly not going to be an adequate basis here. And so I'm glad you asked that question, because I think that's a very important point here.
So it would be a treated substance use disorder?
Correct.
Or something for which she is in active recovery?
Correct, exactly. And I mean, again, maybe that's something she has to do for the rest of her life, but she's doing it since 2009, no evidence to the contrary, so that cannot be a factor. And then when you look at what other evidence there was here, there was really nothing else showing that she had a substance use disorder. Now, I mean, the judge made a finding about, well, her pill counts on her Adderall weren't always accurate, we don't really know what she was doing. Well,
I think we do know. She frankly admitted on the witness stand that she was sometimes selling it to make money.
Yeah, I think, and I'm remembering because mother's take in conversations I had with her was a little bit different, so I'm not sure if I'm remembering the record or what she's told me. But even if you assume that's true, and I'm not going to debate that, if the testimony's there, or even if there was other evidence that was there, I'm not going to debate that here, but that doesn't rise to the level of something that puts the children at risk. And so, I mean, if she was, I would agree that if there was evidence that she was back on the opioids, and even if it wasn't rising to the level of harming the children while the older one was still in her custody, but she was back on the opioids, I think then that's when Catherine kind of kicks in, and you've got the whole situation of we don't have to wait for the ultimate disaster to happen. I mean, clearly she had this problem in the past. She's still using,
But she acknowledged the housing was unsafe. Didn't she say that the man she was living with poisoned or attempted to poison one of her children?
She did. That's separate from the substance use disorder, though. So that was one of the other legs on the stool. And, as I said, I think there's issues with all four of them. Housing and financial by themselves are never going to be enough to terminate parental rights, because if we're going to do that, then every poor parent out there is already halfway to termination of their rights.
So my understanding of the way that the judge, or the way I read the judge's use of the housing instability, was not to penalize the mother for being poor and not having her own home, but to question whether she had the ability to and had shown that she was capable of acting in the best interests of her children, where she had admitted that this was an unsafe housing situation, nonetheless stayed in it for, I think, 6 years at the point of trial, been offered opportunities or resources from DCF to move into more suitable housing and not taken advantage of them. So it's not, again, my read, tell me if I assume you see it differently, but I'd like to know why. Not that she is in a bad living situation, but that she's not showing that putting the children's best interest comes first, given her reaction to that situation.
Well, no, and I agree that there was evidence to that effect and that the judge did make a finding to that effect. But then the question becomes, is that alone enough to constitute a grievous shortcoming that puts the children much at hazard? Which is the ultimate standard.
I mean, let's assume for the moment, which I'm certainly not saying on behalf of anybody, and I don't speak for these guys, but assume for the moment that the substance use thing goes off to the side. Why then are we looking individually at the other things and not taking a holistic view? No,
I think we can look at it both ways, but the problem is the judge, I think we'd have a different situation. I'll use the housing as an example. If the judge said the housing situation alone is grounds for mother to be unfit because she didn't put the children's interests first, she didn't follow up on services that could have potentially gotten her out there. If the judge said that, then I think I'd be making a completely different argument here. But the judge didn't say that. He said 4 things: housing, mental health, financial, and the substance abuse issues. And he said, I'm not giving any one of these particular weight. I'm saying all of these are factors. So that's a 4-leg stool, and I argue that one of those legs needs to be knocked out. And I mean, you're assuming it for the moment too.
I hear you, and that's how it's framed in some sense. But he made a lot more findings than that. I mean, there's findings.
I missed that. I'm sorry.
The judge made a lot of findings that touch on a number of other issues, such as the mother skipping out on 4 days of trial, such as missing half of her visits at one point, I mean, the list goes on and on. There's actually more teeth to this than you're stating right now.
No, correct.
I'm not saying that there's not a measure of persuasiveness to your argument.
So
when
I argue the 4 points, and I agree that the issue with the visits is in there. The what was the first one you said? It was
skipping trial.
Skipping trial. Oh, well, and I do want to address that
Negative
separately.
inference drawn from that by the judge.
But the primary 4 reasons that I'm quoting from are from paragraph 27 of his conclusion. So yeah, there's a lot in this 41-page decision that can go all over the place. But in paragraph 27, he really kind of says, mother is unfit because A, B, C, D. So those are the 4 most important ones. Those other ones do touch on it. Now, as far as mother not being at trial for 4 days, in this case, she did testify. Now, my understanding of the case law, at least the reported cases that we all have to follow, is that you can draw an adverse inference from a failure to testify. And the purpose of that, which I think is addressed in the Nadia case, is that when DCF or whoever the petitioner is in a particular case makes enough of a showing to suggest the parent is unfit, then the courts should expect the parent to answer to that. And that's getting up on the stand and testifying. Here, mother did testify. She didn't attend all the days, and I'm not going to speculate as to why. I mean, I can't remember if there was any reason given at some point in the record, but she did testify. So those cases, the reported cases that talk about the adverse inferences, talk about failure to testify.
You know, I'm glad you brought that up when she testified, because the judge has an advantage that we don't have in that he put eyes on her while she was testifying, and he seemed troubled by the fact that at a point she seemed pretty good, at another point she didn't, which suggested there was some issue going on with her medication or whatever. So he sort of had a first-hand look at, you know, her abilities to deal with these young children, just based on that alone, which, you know, we don't have that here.
Correct. No, and certainly findings based on that are entitled to a level of deference. I mean, I think that's pretty elementary, and that's true. But again, I mean, had the judge, I mean, I hear those things as mental health factors, that maybe she wasn't in the right state of mind that particular day or whatever. But if the judge had said...
It's kind of an important day, though.
Well, correct. But I mean, she could have been stressed that day, too. I mean, I wouldn't want to be in that position, you know. But if the judge had said, I find that mother's mental health is enough of a reason to find her unfit, for all of these reasons, including what I observed in the courtroom, again, it's a different argument. But he didn't say that. And I've cited some cases. I think I cited 2 batches of them, one in my primary brief and one in the reply brief, where when there's a number of factors that are all considered in the aggregate, and one of them has been knocked out for whatever reason, error of law, whatever, a remand is needed because you don't know how much weight the judge gave to the rest of them. I mean, there's an SJC case. It was Brown, I think, petition of Brown or something like that. That's exactly what the SJC said. They said, basically, we would agree with this interpretation, but it's the trial judge's job to make it, so they sent it back. And that's why, in this case, it has to get sent back. The judge did not say that any one of these other factors alone, or even... The judge didn't even say the first 3 factors alone are enough, and then also there was the substance abuse thing. He considered them all together, and that's that paragraph 27. He says it right in there.
A 41-page decision, single-spaced, and you want us to discern from that a certain emphasis on some things versus other things?
Well, I mean... First of all, I do think that that's not unreasonable, because this paragraph 27 really seems to be his, I mean, it's sort of in the middle there, but it seems to be his summary of here's what I saw at trial, and here's what was wrong, and here's why I think she's unfit. That paragraph really says it. Everything else sort of supports it. And there are some inconsistencies in there. Absolutely there are. But again, those need to be resolved by him. You know, but when you look at the summary paragraph, he's saying it's these 4 things all together in the aggregate. And I mean, we're not spending a lot of time on the possible substance abuse. I'm hoping maybe I have you convinced on that one. And if that's the case, I think it has to go back and he has to look at this again and say, all right, now what do we have left? And is that enough to terminate? And in cases like this, I think the law says that you give the mother an opportunity to say what her current level of fitness is. So, I mean, in theory, she's even getting a new trial on that. But at minimum, it has to go back to the judge to take another look at this, for sure. I don't usually stop when I still have a green light, but unless if there are any other questions, I think those are the main takeaways I'd like you to
Thank you. That's very helpful, and the record will reflect that you have an extensive, very helpful brief as well, which
great.
we'll
Thank
also
you.
consider. Thank you.
Thank you.
My understanding is council splitting its time equally?
Yes, Your Honor.
Thank you. Good afternoon.
Good afternoon. May it please the court, Richard Salcedo for the Department of Children and Families. I'm joined today by counsel for the children. The department is asking this court to affirm the trial court's decision finding mother unfit and terminating her parental rights. A review of the court's 157 findings of fact show that close attention was paid to the evidence, and those findings taken together clearly and convincingly support the trial court's conclusions. Turning to the substance abuse issue, as Your Honors mentioned, mother acknowledged that she had an opioid addiction in the early 20s, and she was prescribed Suboxone in order to treat that opioid addiction. And part of Suboxone treatment prescriptions is that it's part of a comprehensive treatment plan. And my brother mentioned that mother had been following treatment protocols, but the evidence indicates that other than taking the Suboxone, there was no other, she had not engaged in any other treatment services, therapy services in conjunction with the opioid, the prescription medication. She had also not, at some point where the department was trying to assess and encouraging her to engage in a medication evaluation, she failed to follow through with that. She also failed to follow through, if you look at finding 121, that the department referred her for substance abuse services, and she refused to follow through with that as well. And as noted, there was the issue of Adderall potential misuse that the department social worker, if your honors would look at record appendix 200, 208, and 211, the social worker testifies about the concerns about the Adderall misuse, and that mother failed to follow through with any assessment of that to sort of confirm that she has a current addiction issue. So, and also it had been mentioned that the court observed firsthand that they had concerns about mother's behavior. They found mother's behavior worrisome during her testimony. There's also a finding at finding 86 that mother appeared to be under the influence at a visit. She was described as glassy-eyed and falling down. So I think if we look at all of that evidence, that the court properly considered the issue of substance abuse as one that they could properly consider along with the other factors that were mentioned. Mother's mental health was also a major focus for the court. Mother had been involuntarily hospitalized on several occasions. She's been diagnosed with depression and psychosis and been prescribed multiple medications over the course of the case. She was not always consistent in taking her medications and not followed through and addressed her mental health issues with treatment and and not complied with her action plan with regard to her mental health issues. Despite her substantial or significant history of mental health issues, mother does not acknowledge that she has any mental health problems or issues, and she merely describes them, her condition or issue, as circumstantial anxiety. The other factors which Your Honors have touched on that were considered were the housing, was the housing issue, which was a subject of a number of the court's findings and conclusions of law. And as Justice Hodgens had mentioned, mother acknowledged that her current living situation, which has been her living situation for 6 years up until the time of trial, was unsafe and unsuitable for the children, and acknowledged that her partner or roommate, who she had lived with, had tampered with baby's formula, and she described him as controlling and a gaslighting narcissist. Pardon me. And as Justice Hershfang had mentioned, despite acknowledging all of these things, mother failed to follow through with referrals for other programs the department had made for her, and she continued to live in that situation up until the time of trial. Mother's lack of visitation with the children was also considered by the court. She missed a number of visits, was often late when she did appear for the visits. She often struggled, and the visits were described as chaotic. So all of this evidence and the findings based on that evidence taken together support the trial court's conclusions, and we would urge this court to affirm the decision of the trial judge, unless there are any questions.
Just a quick question about one of the facts, that there was when each child was born, one of the reasons that the DCF was notified was that there was a positive screening for amphetamines. I think it's argued that could be explained by the mother's prescription medication at the time, namely the Adderall. Is there any evidence or anything in the record before us to counter that apparently reasonable interpretation?
Now, I think the court does mention or does find that mother was prescribed medications at the time, and so I don't think that that was an issue that the court had any concerns about. I think it was more mother's behavior. She was requested by medical providers to bring the child in at some point to be examined, and failed to do so during her prenatal care was lacking, and there were other concerns about behavior when she did bring the children in. So I don't think that alone was any major concern for the court.
Thank you very much, and we'll have to leave it there.
Good afternoon, Your Honors. Peter Heffernan on behalf of the, may it please the court, Peter Heffernan on behalf of the two minor children, child one, the older child, child two, the younger child. With respect to substance use, Your Honor, to Justice Hershfang's point, the court could have inferred from mother's treatment plan that mother had, in fact, a substance use disorder. I would argue that the court did not make a finding that mother had a substance use disorder. The court was concerned about mother's misuse of her prescription medication based on unchallenged and admitted evidence with respect to her management of her own prescription medication. The court entered several findings that related to mother selling or giving away or having stolen some of her Adderall. The fact that
that's different from a substance. I mean, I guess this is sort of hair splitting, right? But that's certainly a misuse of a prescribed substance. And a crime. But it seems a little awkward to characterize the sale of one's own prescription medication as a substance use disorder.
And I don't think the judge did that, Your Honor. I think the judge noted mother's inconsistency. In fact, the trial judge entered an order that mother's inconsistency with respect to her prescription medication was a contributing factor to her overall instability. And I think that was amply supported by the record, particularly by the judge's observations of mother at trial on October 18th, during which she is veering between giggling and crying on the stand, is unable to stay on topic, and is presenting as somewhat dysregulated. She had testified that she had...
I just want to be clear, because this kind of struck me when I was reading the brief, but I went and looked at the transcripts, and I mean, not the brief, the rulings, and the judge didn't get this wrong, that the day on which the judge perceived the mother as dysregulated was the day on which the mother testified she was taking her Adderall.
After having taken herself off it, and then in response. But it certainly, with respect to the, in addition to the other concerns raised about her prescription drug use and the consistency of that use, the judge considered that as a factor among a constellation of factors bearing on mother's capacity. We haven't spoken about mother's mental health, which I think is a key proponent to the judge's overall assessment of her unfitness. On 2 occasions, mother brought child 1 to the emergency room claiming incorrectly that child 1 had serious health needs, reporting incorrectly child's symptoms. As a result of both of those incidents, mother was involuntarily committed for not insignificant periods of time. One I know was 9 days. It's not clear from the record how long the other commitment was, during which she was diagnosed with depression psychosis. Now, she maintained up until the end of trial that that was not a valid diagnosis. She had no mental health diagnosis outside of situational anxiety disorder. The trial judge considered mother's lack of progress in addressing her significant mental health needs as part of that constellation of issues that contributed to her unfitness. With respect to the inference, there's some discussion by counsel for mother regarding whether the court was permitted to make a negative inference from mother's failure to attend trial, as opposed to her, where she in fact did testify. Adoption of Helga answers that question for us, and counsel refers to it in his brief. There, the mother missed 2 days without excuse. Here, the mother missed at least 4 days of trial without excuse, and there was no error in the trial judge drawing a negative inference. He indicated that that inference was one of several factors which he was considering in assessing mother's overall fitness. I'd also point out, because counsel for mother points to Patty as a case that may qualify Helga, and it doesn't. Patty involved a case where the trial was virtual, and the court drew a negative inference against mother because mother did not attend, but had not established that she had the technology. That's a very specific set of circumstances. It doesn't modify the finding in Helga that a negative inference would not be improper here. Finally, Your Honor, I would just note on behalf of the children that mother is here asking this court to remand the case back for a new trial. I don't believe that's warranted. I believe that there's no error of law, there is no abuse of discretion in the trial judge's decision that would warrant a remand. Mother had a trial. She appeared for only 2 days of the trial. And at the completion of the trial, Mother was not there for closing arguments, but on her behalf, her trial attorney argued, did not ask for custody to be returned to mother, did not maintain that mother was prepared at that time to care for the children. She conceded that mother agreed with permanent custody of child 2 to the department, guardianship of child 1 to the guardian. And there's nothing in, one of the findings the judge did make is that there's not an indication here that mother's unfitness is temporary, that mother is going to take the steps necessary. She doesn't acknowledge the issues that have been raised here. There's no indication that she's going to take the steps necessary to address her parenting deficits.
How old are the girls now?
Child 2 will be 5 in April, child 1 is 3.5.
And oh, sorry, I thought they were the other way around. And so the younger child has never lived with the mother since
correct.
She was born. And then the older child briefly lived with the mother.
Till she was 1 year old. In closing, Your Honor, I would just argue that the children deserve permanency. They deserve a stable childhood. The judge's determination, terminating mother's parental rights, finding her unfit, furthers that goal and was the correct decision under these circumstances.
Thank you. These are difficult cases. We appreciate your arguments and your helpful briefing. The case is submitted, and that concludes our session. I'd like to thank the court officers and clerks today, and we stand in recess.